Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Prosecution, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. Not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Oh, good morning. Good morning. Good morning, my friends, and thank you so much for coming to spend part of your Friday, January 31st with me. Well, that went fast. Where did January go? They're already coughing into the mic. It's going to be a morning. I'm getting ready to go into the Karen Reed hearing today in Norfolk County, Massachusetts. How's everyone? Yeah, no, I don't think they're going to assign a new judge. Sorry, law junkie. Judge Cannone has been ordered specifically to stay on this trial by special order. Oh, look. Wait, the sound is up. Alessi just walked in and he gave her the nicest, biggest greeting. Watch this. What a nice guy. Let me hear if you can hear. Let me know if you can hear it okay. The sound's not great yet. Well, that's Mary Ellen, everyone. Everyone say hi to Mary Ellen. Hey, Mary Ellen, how are you? I like his vibe. His vibe is really nice. For those of you who don't know, that's Robert Alessi. He is a New York attorney who has joined the defense team pro bono, which means for free. He believes so deeply in Karen Reed's innocence that he has stepped in from New York. He's been admitted pro hoc vice. I'm here for it. Exactly. No, we want to know who Mary Ellen is. Who's Mary Ellen? Good morning, Poppersky. Thank you for coming in with early morning super chat. How possible, hypothetically speaking, would it be to prosecute Cannone for aiding and abetting abuse process? No, judges have judicial immunity, so that is not possible. But it's a good question. I don't know if it was a sarcastic question or a real question, but judges, cannot be prosecuted unless they do something that's actually criminal. And as judges, they have very wide, broad judicial discretion. Lori Life 360 for the win. Thank you for gifting 5 memberships, my dear, so early in the morning. And to those of you who were randomly gifted by YouTube, you need to be opted in to receive gifted memberships, and YouTube randomly chooses them. I do not have any control over that. Thank you so much, Lori. It's good to see you this morning. And Justin Green, thank you for sending a Cash App this morning. As always, for your support. How's everybody doing? So this court officer who's coincidentally bald. Oh, wait, here's Brennan. Hold on. Let's hear him. Is he going to say hi to Alessi?
It's good that you asked me because you never know with me, right? But I'm learning. I learned my lesson. You never. And they're demonstrating.
Notice the difference. Alessi walks in. He's a New York lawyer. He doesn't know anybody here. This is maybe like his second time in the building, maybe third. greeting everyone, says hello to everyone. Let's see if Brennan even says hello to Alessi.
And they're demonstratives too, so it's oral argument. It's not like. Well, it's good that you asked me because you never know with me, right? But I'm learning.
He legit just walked by Alessi, didn't even acknowledge him, didn't even say hello. Did everyone see that? Oh, so he walks over and says hi to Alessi. I mean, to Brennan. I don't know. They obviously didn't say hello in the hallway because Alessi had to go over and introduce himself to him. It's like the big swinging duck contest sometimes. You know what I'm saying? Bulldog Mom, good morning. From Wyoming. Thanking me for my coverage. Thank you for watching from Wyoming and for being with me for 7 months. Mrs. Bucket's been with me for 9 months. Looking forward to spending my afternoon with you. Where are you, Mrs. Bucket? You in the UK? And Amanda's been here for 4 months. Thank you, Amanda. Love you all, each and every one of you. See how full the courtroom is today. How many of you? So we were watching. Was it yesterday already? It was yesterday. We are currently watching the Penny McGee trial, which is also in Norfolk County, also in front of Judge Cannone in this exact same courtroom. It is a bench trial. Her attorney and the defendant, Penny McGee. Oh, here's AJ.
Morning, I'm away from Mary Ellen. I'll ever get to. Yeah, a couple of transcripts. And
AJ's beard is back in the courtroom. I wonder if he took the red eye, Mr. Jackson. Do you think he took the red eye?
just in case I'll ask them if they're already.
Penny McGee. For those of you who don't know, it's really interesting. Larry Tipton is her assigned counsel. He's a public defender. He's also defending Brian Walsh. Penny McGee is a socialite from Rhode Island. She was married to a guy named Andrew Savitz, who was very politically connected. He ran Michael Dukakis's 1988 presidential campaign. They were divorced for about 6 years. They were raising 3 children together. She was living in a house that his brothers owned in a trust. His brothers decided to evict her from the house, and her kids lived with her, I think, part-time. Some lived with the dad part-time. She went over to talk to him about an email that she got, or confront him about an email she got from the brothers evicting her from this house in Brookline, which a lot of people did not realize is in Norfolk County, but it is. She goes over they start arguing. Now, Andrew Savitz, the ex-husband, had a lot of medical conditions. He had had a stroke like 6 months prior. He had 2 major car accidents in the months leading up to this. He also had hypertension. I think at autopsy, it was found that he had a 90% occlusion of one of his, maybe it was the right descending artery of his heart, and some other things. She went and had an argument with him. And during that argument, he had a heart attack and died in the foyer of the home. And she was a year later indicted on manslaughter charges for having this argument with him, which the medical examiner says led to his death. It's wild. It is wild. She's facing 20 years in prison. Judge Cannone is the judge, and she is going to decide her fate. Let me know, would you let her decide your fate? I know that Mark Betterow has said many, many times that he's a big fan of the bench trial in the right circumstances, but not in front of Judge Cannone. So this is going to be interesting. No, it's not over. So I've done 2 shows catching us up on it. The first show we did on Thursday night. We caught up on the whole trial because, of course, it's half day Bev. So we got all the testimony in. Friday was only 1 witness. It is going to start again. It's going to pick back up again on Monday. So we're going to start covering it live because it was not broadcast. I had been watching it or listening to it only on Zoom. And the only other way that you could watch it was on Court TV live. But they kept cutting off the testimony. And like the daughter's testimony was so important because the daughter, her name is Zuzi. She and her mom were estranged and she did not like the mom at all. And she's their star witness. But then when Zuzi got on the stand, she's like 23 now, maybe. She said a whole bunch of stuff that she never told any of the troopers, including Yuri Buchanek, who has not testified. I don't know if he's going to be testifying, but Monday is going to be fired because the medical examiner is going to come in. And I'm so anxious to hear if the medical examiner is going to say that somebody strong-armed her into changing her opinion, because the medical examiner's report says something like the cause of death was hypertension in a person with severe cardiovascular disease that caused a heart attack that was preceded by an argument. It was called in as a domestic because the daughter claimed on the 911 call that she saw her mother push her father. But Penny's statement to the police was that he picked her up and he was pushing her and he slammed her against the wall and then he was pulling her by her hair. And now this woman is literally on trial for manslaughter in Norfolk County. Welcome to the upside down. So that is the Penny McGee case. We're going to be picking it up again Monday. I think Monday's going to only be a half a day, but it's wild. Never seen. No, it's a different medical examiner. Her name is Rebecca. I think it's Rebecca Diedrich. And the name sounded familiar to me, and I'm not sure why. Oh, here's Miss Yannetti. Hold on. They're already tapping on that mic. Good morning, Miss Yannetti. So we had all those medical issues, but still poked and provoked. They were having an argument. I don't know. You mean she was poking and provoking him? I don't think there's any causation. I don't think she caused his death. So I find it to be a tenuous case, but welcome to Norfolk County. It happened in 2020 and it happened on he died on January 29th of 2020, which is exactly 2 years to the day before Officer John O'Keefe was murdered. So it's crazy. It's Massachusetts. We're here for it. Join us Monday morning because it's fun. Is that Gretchen Voss? No, that's Christina Rex right here. The blonde. She's the one who got the exclusive interview, remember, with Paul O'Keefe. I forget what channel she works for.
Whatsoever at all. Somebody is on the laptop and all that, but no cell phone use whatsoever today. Thank you.
No cell phone use whatsoever today.
It's a little better.
And that's how it should be in most courtrooms. Everyone should have their cell phone away. There's nothing worse than having someone's cell phone go off in the middle of a court proceeding. We saw that in Sarah Boone. And we were trying to figure out who it was. And then we found out who it was. And it was Susan Constantine, who you may recognize the name from. I think she's a body language expert. She has a talking head on a lot of channels. And she also, I think, was on the Glare one time. And they had some sort of spat. I can't remember what it is. Oh, there's my friend Tim. I think his name is Tim from Canton Community TV. Very nice guy. Yes, that means you GSL. He who we don't speak of. Thanks, Moon Goddess, for gifting a membership. Good morning, my dear. Dr. Russell's CV, aka Hey D&E Pizza. Thanks for tuning in from Oklahoma. We gotta get back to that Oklahoma case with the granny murder case, Tiffany Adams, and the tragic case of the two moms from Kansas who went missing and were killed by the granny and her 4 accomplices or something. We got to get back to that. I don't know that anything has happened lately. Thank you, Beth, for your super chat. Magnolia Gypsy's been here for 11 months. She says it seems like yesterday. Thank you, Paula M, for gifting a membership. This should be fiery today. I'm very excited. And Alessi seems like he's in a very good mood. He's ready to go. Hi, Beth. Beth is Team Alessi. Thank you so much for your super chat. Chris D, ready, set, go. Thank you, my dear, for your 10. Swinging ducks is animal abuse. Thank you, John Common, for coming in with that super chat this morning. Swinging ducks is animal abuse. I don't know what that means, but it's early and I haven't had enough coffee. Mrs. Bucket, thank you for your super stick. Paula gifted 5 memberships. Thank you, Paula. Very, very generous of you. Oh, thank you so much, Dilba Mama, for the compliment. Appreciate you and for hanging out for 6 months. Free Karen Reed says Kevin Higgins, justice for Officer John O'Keefe. Get well, Tom. CPO. Oh, is Tom sick? I'm sorry to hear that. Tom, get well. A lot of people are sick. There's a lot of stuff going around right now. A lot of stuff going around. Caroline, hi to the UK. Looking forward to the hearing today. She's here for it. Moon Goddess, thank you again. Oh, Barbara, thank you so much for a $50 super chat. You're the greatest. Let's have a great day for Karen. I don't know. I don't know what's going to happen today. I don't know if she's going to order an evidentiary hearing. In fact, I don't know if they're just going to argue the motion on papers, Richard Green's motion. And we saw, for those of you who were with me yesterday, we went over in its entirety the revised affidavit of Richard Green, who's the expert, who, interestingly enough, he had a lot of opinions on the stand, but the only opinion that the Commonwealth is worried about is his opinion with regard to Jennifer McCabe's 227 Google search for how long to die in cold. So they're okay with all of his other opinions. It's just that one opinion that they don't want him to be able to testify to, which is, I don't know. I would say it's interesting, but it's really not. It's kind of par for the course. We feel like they've been running defense for the Alberts and the McCabe, at least for the entire first trial. Good morning, Karen. How do you guys feel about no shave January for Mr. Jackson? Are you a fan? We did take a vote on that one day, and it was highly in favor. Mr. Reed, good morning, Mr. Reed. Oh, there's Esty. For those of you who don't know, this is Esty right here with the long blonde hair. She does standouts everywhere. Oh, there's Tim Bradle. Good morning, Mr. Bradle. She does standouts all the time by herself. She'll go to the State House with, her cute little outfits. She's always very well dressed, and she will have a sign, and she will just be out there by herself. She is so dedicated to the Karen Reed Innocence campaign. Thank you, Barbara, again for your super chat. On top, thank you for your super sticker. Good morning. You're on top of it today. Martha, thanks for being here for 11 months and for thanking me for being here with you. Ain't no place I'd rather be. Ain't no place I'd rather be. Oh, love you, Dave and Tim. Thank you, Heather. Oh, it's not really. It's more bronzer. When I was in Cancun, it was rainy and cold most of the time. So, it's a little bronzer. It was cloudy. It rained during one of the concerts, and it was outside, but it was still beautiful, and it was still a wonderful time, and a much needed break. I plan my vacations usually around concerts because that's my happy place. And so every now and then you need to set the reset button of life. And for me, that's what that is. So I do that every year with my sister. We go to Cancun for Dave and Tim, and it was an amazing time. That is something that we do together. Thank you so much. And for those of you who were with me when I live streamed a little bit of the show each of the 3 nights, those of you who were in the chat really loved it.
Okay. Anything for me?
Yes.
This is one.
The other interesting thing in the Penny McGee trial is in the same exact courtroom, Colleen Crawford is sitting at the table with the prosecution. So Colleen Crawford, who has been named as an expert witness for the Commonwealth, is on the prosecution team in the Penny McGee case. A lot of crossovers. It's like a crossover episode of the Karen Reed trials in the same courtroom. But check this out. See where Karen Reed's family is sitting behind Karen. And remember during the trial how the O'Keefe family was sitting right here to Karen's left, staring her down the whole trial. Well, in the Penny McGee trial, it's reversed. So it's her friends and family that are sitting here to her left, looking at her, and the victim's family is sitting behind her. And in my personal opinion, that's the way it should be for this case too. Because you remember what happened during closings. when Brian Albert, Colin Albert, Jennifer McCabe, and oh, why is law and crime buffering? They were staring down the jury. And some could say that that was, intimidation. But that's my opinion, and I'm sticking to it. Jurisprudential maladies. Thank you for becoming a new member. Cherie, good morning. I heard Rich won't be there today. Rich who? Rich who? Richie from Microdots? Paula, thank you for your super sticker. And thank you, Double Moma, for your super sticker as well. Cat's Meow, thank you. Cat's Meow 420. Thank you, me? No, thank you. Is that Karen's mom? You're next to Mr. Reed. Karen, yes, she is right here. The reddish sort of auburn hair. That is Karen's mom.
And the judge turned around and the clerk said, show's over.
Still a lot of chit chat. Shelly, 1466, thank you so much for gifting 5 memberships. Thank you for your kind and generous gift. True Crime Grammy. Good morning to Kansas. Kansas and Oklahoma in the house, and Wyoming. This is a worldwide story. This is a worldwide story. It started out as a Boston area story. It has quickly grown to a nationwide story and now a worldwide story. So tell me where you're watching from. I found out who Mary Ellen is. Mary Ellen is Hank Brennan's paralegal that he brought in. Remember, Hank? Oh, if you are tuning in late, Mr. Alessi walked in and gave a huge welcome to Mary Ellen. He said, "Hi, Mary Ellen." And here's Paul O'Keefe in true form, positioning himself in such a way that he can watch Karen the whole entire time, in my opinion. And his wife Erin is with him today. That is Erin on the left, to the left of Paul on your screen. Wonder who else is coming. Oh, there's the ex-girlfriend of John O'Keefe from about 25 years ago. This is Mrs. O'Keefe, John's mom, on the left of your screen. Bino from Ireland. Michael and Ann Behan, thank you so much for your super chat. Is that Gretchen Voss? I'm not sure. I don't know what Gretchen Voss looks like. Gretchen Voss is the reporter who did the article for Boston Magazine, who has been the subject of many motions to turn over. It is Gretchen. Thank you, Tracy. To turn over her notes and voicemails and emails that had anything to do with that story that she wrote about Karen Reed. And some of you may be saying, what? She's a reporter. Don't they have a privilege? Well, not in Massachusetts. They don't. Welcome to Massachusetts. There is no journalistic shield or privilege in Massachusetts. And so they had to turn over lots of things and stuff that reporters in New York or other states that recognize a privilege. Most states do recognize a journalistic privilege in the United States. There's only a handful of states that don't. Massachusetts is one. So nothing is technically off the record.
Silent modes, please. All cell phones, please.
So this is a very tiny courtroom. For those of you who are joining for the first time, only 10 seats available for the victim's family and friends, which are sitting right here staring down Karen Reed. Behind them is a high top, which has 10 seats for media. And then behind Karen is her friends and family section, for which there are only 10 seats. There are no seats open to the public in this courtroom due to the size. The defense asked to move the trial to this courtroom or a different courtroom in the building because the main courtroom, the beautiful historical courtroom where I believe Sacco and Vanzetti were tried in that exact courtroom, the positioning of the witness box in that courtroom is such that the jury, or at least half the jury, is staring at the back of the witness's head. So the defense had to make a motion to the judge to say that that was unconstitutional because the defendant has the right to face their accusers, and number one. And number two, the jury needs to see the faces of the witnesses in order to assess credibility, which I completely agree with. Judge Cannone said to Mr. Jackson, or I can't remember who was arguing it, we've been trying cases in that year, in this courtroom for 100 years, Mr. Jackson. No one's ever complained about it before. That's the way it's done. And he said, I don't care about the way it's done. I care about the way that it should be. And so I guess as a penalization, they were moved to this tiny courtroom. Rescue Puppy is on the road to Austin, from Ohio to Austin, Texas. Good. I'm glad we can keep you company on the way. And here's Norway in the house. Dr. Russell is the GOAT from Norway. Thank you so much for your super chat. This is free Karen Reed. This judge is usually always on time, but it's 9:12 right now. It was supposed to start at 9. Who else do we notice? Do we notice anybody else? Karen looking like a queen, says Christina. I wonder what the total price tag on her outfit will be today. They love to do that on Twitter. Look at this bag that she has. It costs $800. Yeah, it also could be 20 years old. Yes, MR 5.0. Jackson has to be tired of all the red eye traveling. You may be right. I may be crazy. But it just may be a lunatic you're looking for. Turn out the light. What song is that? We thinking song lyrics here. $800 bag could have been a gift. Or maybe before this trial, she was making lots of money as a financial analyst and a professor, I believe, at Bentley. Since then, she has grown to be $5 million in debt with regard to legal fees for this persecution. And now the retrial. She's tapped out her 401k. She sold her house. I think her parents have mortgaged their home to finance this trial. And many, many of you have been generous enough to donate to her fund for legal fees, which goes straight to her attorneys. And remember, my friends, if this can happen to Karen Reed, this can happen to you. John O'Keefe was not hit by a car. And a car did not hit John O'Keefe. That's my opinion as an attorney with over 30 years experience in civil litigation, handling thousands of car accident cases. The injuries that John O'Keefe sustained did not come from a car accident, no matter how much they want to gaslight you into believing that they did. They just didn't. Billy Joel, you may be right. Thank you, thank you, thank you. Odyssey. Did anybody watch the Fire Aid concert last night? It was broadcast all over. I think it was on Netflix, and I kind of forgot about it. And then I saw that John Mayer's YouTube channel was streaming it live, so I was lucky enough to catch John Mayer. And if you guys watched it and you saw somebody that you like, thank you, Lugo, for your super chat. Let me know who your favorite performer was. Hi, good morning. The slowing down the chat screws up the algorithm. So if you need to, just put your finger on the chat and you can slow it down on your end. Thank you, though. Watching from Arizona. The gang's all here. Laura's here. Good morning. Sleeper Cell Spy. I can't remember. Good morning. You guys are up early in Arizona, huh? Exactly. This meatballs burner phone. I don't know. It's pointless to try and argue with people who don't understand. But when you buy cheap, you buy often. If you buy well-made things, they last for 20. I have stuff in my closet that's 25 years old at least. Buy classic stuff, it never goes out of style. Take good care of it. Or, you could be buying that bag at TJ Maxx too. So, I mean, give me a break. Hi, Kimmy. Kimmy was the first to say Billy Joel, but did what's my prize? A free membership? I can't do that. There's no way for me to gift a membership. You have to be randomly selected by YouTube. I can't even give them out. Like I can't say, here's one for you, here's one for you. Lori says, I'm pretty sure I have a few things that are over $800 that weren't practical. You may be right. Billy Joel, a way to start the morning. That's right, Vanessa. You get it. There's Mr. Lally. Mr. Lally, Ms. McLaughlin. And a hush has come over the courtroom. Around the world, science is real. I dig. Nikolav lives in Norfolk County and is so tired of this ducking nonsense. Says, I don't know how Karen stays so strong. Isn't that the jury with their back towards us? Hi, Cajon Zone. Well, that's where the jury would sit, but there's no jury here today. But yes, this is the jury box right here. At the bottom of your screen. Looks like there's some media sitting there today because they all have their laptops out. Oh, Turtle Boy's there? Oh, is he in the courtroom? I mean, is he in the media box here? Aiden's on the right. Oh, I see right here. Okay, got it. Looks like he got a haircut. Every woman says Bev must be finishing up her cranberry scone. Maybe. What is the bow on McLaughlin's head? That's a great question. It looks like a cheerleading bow, but I can't be quite sure. And here's Clerk Jim. God save the Commonwealth, my friends. Next to Ted. Yes, this is Ted. Is that Matt? I think that's Matt Johnson. Is that Matt Johnson from Court TV? Or that's not Ted Daniel, is it? Somebody said something about a Birkin. Did you hear about the Walmart Birkins? I ordered a Walmart Birkin for $79 and I had it in my cart and I bought it. And right after that, got canceled and I was so upset. I really wanted that Walmart Birkin. They're calling it a workin. You know. Bethany Frankel was talking about it. And I was like, oh my God, I have to get one. I went on the Walmart website and I had one. It was a beautiful color. It was like green. And it got canceled. Nope, hasn't started yet. You haven't missed a thing, Jen. Did Karen hire attorney Michael Bodden? Well, Michael Bodden is not an attorney. Michael Bodden is a medical examiner who's an expert witness who's been around since at least the OJ case. But I don't think that's him. He's got a file in his hand. I think he may be an attorney on another matter. Or you know what? He maybe did. I think he's the attorney for Boston Magazine. I think he's Gretchen Voss's attorney. I don't know. They may be arguing that motion too because they are still fighting that motion. Yeah, that jury box is up close and personal. You better have a tin of Altoids in your pocket. And that is one thing about Mrs. Reed too. She always has mints. She's always passing out mints. She's the kindest woman. Not enough room in the press box for Gretchen. Her attorney is there. That is her attorney, right? I thought I recognized him. So I recognize some of these people from like this guy next to Paul O'Keefe. Wasn't he one of the guys that was in one of the documentaries that they've done about this? Like he was a childhood friend maybe of John O'Keefe. And then the woman sitting behind Paul on the right side of your screen, isn't she the woman? I think her name's something like Tara Kerrigan, who dated John like 20 years ago or 25 years ago. And he was like the one who got away. Robin Rowe. That's a great point. Maybe the designer of the purse is a Karen Reed supporter and gifted it. Yeah, 100%. Alessi looks like a young David Letterman. I'll allow it. All rise. Really?
Justice of the Norfolk Superior Court, Uniform County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Judge, this is 22-117, the Commonwealth versus Karen Reed. Can I have counsel?
Good morning, Your Honor. Hank Brennan for.
Oh man, don't even tell me.
Mr. Jackson.
Good morning, Your Honor. Robert Alessi. I'll be.
It's law and crime, you guys. It's
Good
not
morning,
us.
Mr. Yannetti. Good morning, Ms. Reed. Oh. Good morning, Mr. Birchie. Okay, let's see. So we've got several matters for this morning that I want to discuss. So first, there's filed a motion to recover expert-related expenses from the Commonwealth, and we'll discuss that in some manner at the end of the hearing today. We've also got Mr. Birch is here on Ms. Voss's opposition to the notes. And then there's the Commonwealth's motion for reciprocal discovery pertaining to the employees of ARCCA. And the last one is the Commonwealth's motion to exclude witness Richard Green's debunked opinions. So those are really in that order, except I think we should start with
She had to say debunked. Notice.
non-party Gretchen Voss's motion to reconsider regarding the notes. And I do want to say that I received this morning a motion to file an amicus memo. The signatory is Mr. Albano. I've received that. I will allow that to be filed, and I've read the motion and the memorandum. So I will hear you, Mr. Birchie.
Good morning, Your Honor. Rob Birchie for Gretchen Voss. I'd like to start by just thanking the court for taking the time and giving me the opportunity to revisit
Sure.
the court's ruling of December 5. That ruling allowed in full the Commonwealth's renewed motion for all audio recordings, interview notes, emails, text messages, and voicemails in the possession of Gretchen Voss or Metro Court.
No, I'm not turning off the
Ms. Voss
captions.
and Metro Court
People rely on the captions. There are some people who can't hear, so the captions need to stay on. I'm not sure why they're bothering you, but I'm not a cupcake. I can't make everybody happy today, Adam. Sorry.
complied with the court's order for production of documents on January 2nd by producing to the court all of the responsive materials, the unredacted tapes and the text messages that involved on-the-record communications by Voss with defendant Reed.
Okay, is it so hard to hear? People are saying it's so hard to hear. I'm going to turn my volume down so that you could turn your volume up. All right, let me know if it's better modulated now. Here's me. Here's the court.
I'm here today to implore the court to reconsider that part of
Here's me. Testing, testing.
its ruling, but also would require Gretchen Voss to turn over handwritten notes of an interview with Reed that the parties had agreed in advance would be off the record. What's in those notes is really a black box. The Commonwealth has provided no information indicating what it believes the notes will reveal, or why it has
You are unmuted.
particular reason to delve into them. So the question before the court is whether the Commonwealth should be entitled to forage through this reporter's notes and compel her to break her promise of confidentiality with the source in the ungrounded hope of finding relevant and material evidence somewhere in those notes that will aid in a prosecution of the defendant. The stakes for Gretchen Voss are considerable. As she set out in her second affidavit submitted to the court with our motion for reconsideration, her effectiveness as an investigative reporter depends upon her having the ability to use the tools of the journalism trade, and among them is the opportunity to reliably assure her sources that certain information they provide to the reporter will be off the record. The precedential stakes are high as well, because the Commonwealth is essentially asking the court to give no weight whatsoever to the off-the-record nature of the notes. And that is what renders a journalist's promise of confidentiality illusory. Off the record is a phrase you hear in virtually every conversation between a reporter and the source. Frequently, it's an interjection in the course of a sentence. This is off the record. The kind of lubricant that allows a source to have a free and full exchange with the reporter
Lubricant was not on my bingo card today.
without having to guard every word they speak. And receiving information off the record is often a technique by a reporter to establish trust and rapport with a source. That source might be a whistleblower, might be a frightened migrant, or might, like Reed, be a criminal suspect. On page 2 of our motion for reconsideration, we quote from Primer on journalism that says, off-the-record interviews, quote, are essential in building trust between journalists and their sources, allowing for candid discussions that can provide context or background without the risk of public disclosure. The result, it says, is to enhance the depth of the reporting and provide leads for other sources. In Ms. Voss's case, she states in her second affidavit, which we filed with motion for reconsideration, at paragraph 11, she says, obtaining information from sources off the record is a normal and critical part of my work. Like most investigative reporters, I frequently agree with sources, including named sources, to keep certain of their statements or interviews off the record, not to be published anywhere. Keeping my word on this is critical to maintaining credibility and trust, and thus maintain source relationships while not interfering with the flow of important information to the public. The court's December 5 order forces Gretchen Voss to choose between either keeping her word to her source and thereby violating the court's command, or else obeying the court's order and establishing herself as a reporter whose word cannot be trusted. It's an unnecessary choice to present to her, at least on the facts of this case. The court shouldn't insist on publication of the off-the-record notes because the Commonwealth has failed to meet its burden under Rule 17 to show that mandated production of the records on the facts of this case would not be unreasonable or oppressive. And also because requiring Voss to turn over these confidential notes would damage First Amendment interests more than it would benefit the public in achieving justice for this criminal defendant. Now, I keep saying on these facts, because it's very clear that the inquiry is a fact-sensitive one. The First Circuit wrote in the Bruno and Stillman case that under Massachusetts law, the task is one that demands sensitivity, invites flexibility, and defies formula. While obviously the discretion of the trial judge has wide scope, it is a discretion informed by an awareness of First Amendment values and the precedential effect which decision in any one case would be likely to have. And in Re Cusimano in 1998, the First Circuit said, oh, that was a case like this one, where that involved a demand for confidential information from an identified source. The same court reinforced the fact-specific nature of the inquiry. In Cusimano, they said, when a subpoena seeks divulgement of confidential information compiled by a journalist in anticipation of publication, courts must apply a balancing test. This test contemplates consideration of a myriad of factors, often uniquely drawn out of the factual circumstances of the particular case. Now, as I noted in the December 5 order, the court drew no distinction between the on-the-record and off-the-record interviews when it applied the Massachusetts balancing test for mandating production of reporters' notes, texts, and audio texts, audio recordings. It did not treat this confidentiality promise as a factor in the equation. That, we submitted, was critical oversight, because whether you call it a privilege or not under Massachusetts law. Massachusetts does recognize that there is some degree of deference to be given to a promise of confidentiality. In Bruno and Stillman, the court said courts faced with enforcing requests for the discovery of materials, note it says materials, not source identities. Courts faced with enforcing requests for the discovery of materials used in the preparation of journalistic reports should be aware of the possibility that the unlimited or unthinking allowance of such requests would impinge upon First Amendment rights. In determining what, if any, limits should accordingly be placed upon the granting of such requests, courts must balance the potential harm to the free flow of information that might result against the asserted need for the requested information. So what are the factors that the court should look at when conducting an analysis under Rule 17 and under the balancing test? Taking Rule 17 first, set out in the LaRouche case, they cite the Nixon case where the Supreme Court ruled that in order to require production prior to trial, the moving party has to show, number one, that the documents are evidentiary and relevant. Number two, that they're not otherwise procurable reasonably in advance of trial by the exercise of due diligence. Number three, that the party cannot properly prepare for trial without such production and inspection in advance of trial, and that the failure to obtain such inspection may tend unreasonably to delay the trial. And number four, that the application is made in good faith and, critically, is not intended as a general fishing expedition. In short, the court was explaining that the special prosecutor in Nixon was required to clear three hurdles: relevancy, admissibility, and specificity. And the court held in Nixon that there was a sufficient likelihood that the tapes contained conversations relevant to the offenses charged, and sufficient preliminary showing that the subpoenaed tapes contained admissible evidence. In this case, however, there's been no showing that the handwritten notes contain information relevant to the offenses charged, and no showing that the handwritten notes contain admissible evidence. When you apply it to the facts of this case, there is uncertain relevancy of the information in the off-the-record notes. Not seeing them, it's hard to know whether they're relevant or not. But there's no specificity whatsoever in the form of a preliminary showing by the Commonwealth that the notes contain admissible evidence. Compare that to the materials the court ordered disclosed. The court found that there were indications in the redacted audio tapes that when unredacted, the tapes would contain relevant and admissible evidence. That's on page 5 of the court's order, which says the Rule 17 standard is satisfied, not only based on the tape. But there's no examination whatsoever of whether the interview notes would be anything more than a fishing expedition. To the contrary, the fact that nothing from that interview that resulted in the handwritten notes, nothing from that interview was used in the story. And that would suggest that the interview did not contain significant relevant information. As to the balancing test and the First Amendment interests, here too, the December 5 order ignores the on-the-record, off-the-record distinction. That distinction matters. Confidential information is extra protection because, as stated in LaRouche, disclosure of such confidential material would clearly jeopardize the ability of journalists and the media to gather information, and therefore would have a chilling effect on speech. The court in LaRouche identified First Amendment interests that militate against disclosure of confidential information. One was the threat of judicial intrusion into the news gathering process. Another was the disadvantage of a journalist appearing to be a research tool for the government. Number 3 was the resulting disincentive to keep outtapes, or in our case, keep notes. And number 4, the burden on journalists' time and records and resources in responding to subpoenas. And if you look, Your Honor, at the affidavit of Chris Vogel that was submitted with our original opposition, He talks about each of those factors in his affidavit in paragraphs 13 through 18. He says he worries that compelled disclosure may lead to a public perception that Mrs. Voss is taking sides in this case or is acting as an investigative arm for the judiciary. Trust in the news media is already fragile because reporters compile information for a living. They will always be attractive targets of discovery for one side or the other. The unrestrained use of subpoenas to compel testimony or documents from reporters will create or reinforce the impression that objective journalists are working as agents of the government or the defense. The fourth estate can only serve its role as a pillar of democracy if it has the public's trust. Second concern that editor Chris Vogel pointed out in his affidavit is that another risk of compelled disclosure is that if it becomes easy or routine to subpoena journalists to hand over their interview notes, the legal and administrative costs of battling or complying will chip away at the precarious resources of much of the media. A third factor that was concerning him was that easy allowance of media subpoenas also risks leading to a decline in investigative journalism altogether. This is the most expensive kind of journalism. Reporting, writing, editing, and fact-checking investigative pieces take significant time and resources. Magazines like Boston Magazine will not be able to risk becoming enmeshed in situations such as this one, with the result that they shy away from controversial topics and the flow of vigorous reporting will suffer. We'll feel we have no choice but to select tamer, less controversial topics for our coverage. Another concern expressed by Editor Vogel is that reporters will be incentivized to destroy notes and interview tapes after a story is published, and that could harm the news outlet if it later needs to follow up on that piece. A fifth consequence is that reporters may tend to be circumspect in the way they gather information, in the way they conduct their interviews, and not be so vigorous in their questioning of sources and their documenting of interview notes, aware as they will be that their work may become the subject of public and judicial oversight. And finally, one factor that separates this case from many other cases out there is that Gretchen Voss has been the subject of invasive vitriol simply for writing about this controversial and very public matter.
Haven't we all?
Public disclosure of her interview notes in this case risks putting her again in the limelight. Now, the court mentioned in its ruling that it appeared that she was no longer in fear of harassment because she had attended every day of the trial. I would submit that that shows that she was dedicated to covering the trial, come what may. She tells me she has in the recent past gotten more pushback on social media, including the fact that one commenter on Facebook, who I won't name, posted her personal telephone number for everyone.
Oh, nice. Somebody on Facebook posted her phone number. So she started getting harassing calls. Maybe she had to change her number. What's wrong with people?
That post suggested I'll call her right away. And she's received several strange phone calls since that time.
And this is Gretchen Voss here on the right side of your screen. Long blonde hair.
Because of the disproportionate harm to First Amendment and Article 16 interests caused by production of the confidential interview notes, we ask this court to consider its December 5 ruling and deny that part of the Commonwealth's motion that seeks those notes.
All right. Thank you very much.
Thank you, Your Honor.
You are
I
all
do have one
set.
point to make to you, Mr. Burt. In the amicus brief or the memo that was filed this morning, I just want to be clear that I am not looking for Ms. Voss's own interpretations as well as her likely impressions and thoughts about the interview and overall story to be provided. But it makes sense to me, and I'm going to hear from the Commonwealth, and if you want to respond first, that any information that reflects or relates to conversations with the defendant must be turned over.
It's a slippery slope.
I'm not sure what the question is.
So I'm not looking, the amicus brief and your argument suggests that if I order these notes to be provided, and just to be clear, I do appreciate that they were provided to me to review in camera. So I can see a distinction between what I'm being told that generally all notes reflect the author's interpretations as well as her likely impressions and thoughts about the interview and overall story. That's not what I'm considering releasing. But I think in this criminal case, the Commonwealth has proven that any material that reflects or relates to communication with the defendant must be turned over.
That's insane.
So what I'm going to propose is that I do believe that there's some material in these notes that I don't need to provide to the Commonwealth, that I don't need to order be provided to the Commonwealth, that are just sort of observations. It's the communication between the defendant that's critical here.
Yes, but how do we know that it's accurate? How do we know that her notes are accurate? How do we know that anyone's notes are accurate? And I have no idea what the notes say, but I can guarantee you that if the notes said, I knew I hit John O'Keefe and left him there, and then if anything was incriminating about them, Gretchen Voss would have published it. It would have been a huge scoop for her. Welcome to Massachusetts. There is no journalistic privilege. And what this judge is about to do by turning over the personal notes of a reporter with regard to her conversations with the defendant is an incredibly slippery slope. I do not think that they are going to necessarily help the Commonwealth in any way. But what I do think is that this is a very sad day for journalists in Massachusetts. Nobody will speak to them anymore.
So I'm going to give you the opportunity to propose redactions to me. I have the notes, and you can propose redactions to things that are not reflective of communication with the defendant, observations, things of that nature.
Well, Brennan, there's nothing in the interview notes that is reflected in the story except architectural details, that there's a rosary on the bureau and the wall is blue, whatever it might be. And I went through the notes with this question in mind. Can you separate the impressions and integrity of the thoughts of the writer from the statements of the interviewee? And I don't think they're distinguishable. I think they're all melded together in one. And frankly, it's her selection of questions that she asks Ms. Reed that gives an eye hole into what her thoughts are about the case. She shouldn't have to produce that work product. And the Commonwealth hasn't shown that there's any more relevancy to these conversations with Gretchen Voss than there would be with any other conversation that Ms. Reed had with anyone else. There's no reason for the Commonwealth to be going after Gretchen Voss as a reporter for this, other than the fact that she's a reporter and she's done the investigative work already that presumably the Commonwealth has already done.
Okay,
Thank you.
thank you. Commonwealth?
You're all set.
Your Honor, I'll simply say we defer to the court's judgment and whatever limitations the court imposes. I have no further argument.
Okay. All right, so I'll take this under advisement. Thank you.
Under advisement. Shocking? No.
All right, so paper 442.
Both.
This is the Commonwealth's motion for reciprocal discovery pertaining to employees of ARCCA. And I know from when we were last in court, the Commonwealth was perhaps having conversations with the federal people to
Federal
see if
people?
you could get anywhere with this. Is there anything I need to know in that regard? And if we need to do it at sidebar, we can do it at sidebar.
Okay, first of all, can Mr. Brennan please find the podium? You're on worldwide television, and you should not have your back to the defense counsel. Walk to the podium and speak. That's the way we do it in Massachusetts. Apparently not.
I don't think there's a need, Your Honor.
Okay.
Although it's not incumbent on the Commonwealth to pursue Rule 14 discovery of a party that's going to proffer an expert, Commonwealth made best efforts anyways. I filed a TUI letter, and I was unexpectedly not disappointed when I received a response last night. It's insufficient, it's inadequate. So the issue of pursuing Rule 14 discovery through the proponent of the expert, that being the defense in this case, is something that is a matter we're going to have to address.
Okay.
I did speak to the defense this morning. Since the TUI letter came last night, they have, I don't want to speak for them, but have asked if we would consider some time so they can respond. I am content if it gets deferred until the next date, but it is an argument that needs to be made.
Okay, who's arguing now for the defendant?
Good morning, Your Honor.
Morning.
I agree with Mr. Brennan's recitation of our conversation this morning. If it pleases the court, we did get that TUI letter. I was copied in on that letter late last night. Reviewed it last night. I think that it'll be incumbent for me to at least analyze that letter in a little bit more detail and utilize that letter in my response to the Rule 14 argument. So if we can have another date.
Sure. Well, we have next week, Thursday and Friday scheduled.
That's what I was
So
thinking.
we'll do this next week and come up with proposals on how we can certainly not violate anything that the federal court has said we can't do, but ways that we can go about it.
We'll be mindful.
All right. So if you can work on that, I'd appreciate that.
Sure.
So I will take the lead from the two of you on that.
Thank you.
Okay. All right. So this brings us to the Commonwealth's motion.
Okay, for those of you who are asking what it means, the Commonwealth has demanded that the defense turn over certain things with regard to the crash daddies, all of the things that they reviewed in preparation for their reports, all of the things that they were given by the federal government to do their investigation and their accident reconstruction. The defense is not in possession of those things because the crash daddies were hired by the FBI. So it is what I'm hearing is that Hank Brennan sent a TUI letter to the feds saying, we need you to turn over all the stuff that you turned over to the ARCCA experts, Dr. Rentschler and Dr. His name is escaping me right now, but we call them the crash daddies, in order to do their accident reconstruction. And it seems that the feds may have said no, but we don't know because I haven't seen that document yet. That is required under Rule 14 discovery, which is automatic disclosure by each side. They have to turn over everything that their experts used in formulating their opinions. And so we're going to have to wait till next week, I think, to give the defense time to respond to that. And then they will argue that next week. So I hope that clears that up. Dr. Wolf, thank you. Dr. Wolf and Dr. Rentschler, thank you so very much. They gave them the reports, but they did not give them everything that they reviewed to come to their conclusions.
To exclude defense witness Richard Green's debunked opinions. So I have received a great deal of pleadings on this. So the Commonwealth's motion, and there was a affidavit attached, a report attached from Mr. Whiffen. The defense has filed an opposition, an affidavit from Mr. Green, and then another affidavit from Mr. Green that doesn't, they're two separate affidavits.
It's just renumbered.
And the affidavits are clearly different in substance. So I'm a little.
Debunked is in the title of the motion, believe it or not. It says Richard Green's debunked, and then it has opinions in quotation marks, not debunked in quotation marks.
Little, I don't know what you want me to think about that, but why don't we hear the Commonwealth on its motion first?
Oh, we found
May
the
it please
podium.
Court, we filed a motion to exclude Mr. Green as a witness regarding 2 points. The first is a claim that a witness's phone made a search for a phrase to the effect of how long to die in the cold at 2:27 a.m. And secondly, to exclude an opinion that there was some type of intentional deletion of that entry. This case, I propose on behalf of the Commonwealth, is appropriate for a Lanigan hearing. At that Lanigan hearing, I suggest that Mr. Green should testify and answer questions about his affidavit and his opinions that he would like to subject the jury to. In fairness, the government would call an expert as well. If this case, as the court proposed, potentially scheduled for next week, Mr. Whiffen would not be available, but Ms. Hyde would be available, and I would call her as a witness. Mr. Whiffen, if necessary, is available later in the month as a witness. My suggestion is there should be 2 witnesses, Mr. Green and 1 witness from the Commonwealth. The Commonwealth witness will be able to explain the science, the data, forensic science, and methodology. And Mr. Green, I suspect, should be in a position to explain his ultimate opinions because what we see in his affidavit is an absence of methodology. Mr. Green has filed 2 affidavits in this case. They are very similar, but there are very significant changes to those affidavits. And it stands out as very interesting, the changes to the affidavits, when I look at them. On number 3, he changes his characterization of what his profession is. He originally calls himself a forensic technician, and then the updated affidavit cites that he's a computer network technician. Now that is odd because usually a professional knows what they do for a profession. Simple
here comes the shade.
explanation of what he does stands out. Also stands out when using technical terms. They either were wrong or changed from the first affidavit to the second affidavit. For example, number 9, he talks about the download as a full file system extraction, then changed to an Apple iOS full file system. My point is that when you look, this isn't simply misspellings or poor grammar. There are terms of art that are wrong between the affidavits or changed. When you're using the terminology of an item that is a forensic tool, such as gray key, it is spelled wrong throughout the affidavit.
Oh my God, really? And you were calling bait stamps for like the first 10 motions until we corrected you. Is he seriously arguing the spelling of gray key? Wow.
To me,
Hold on.
it is spelled of an item that is a forensic tool, such as gray key. It is spelled wrong throughout the affidavit. And so it seems to me that Mr. Green's affidavit had some assistance in building it. And the tone of the affidavit supports that
The tone?
thought. When we look at Mr. Green's affidavit, it is not that of a forensic examiner, it's that of an advocate for the defense. When we look at his affidavit, there is quite a bit of advocacy, and insinuations and surmise and conjecture and claims that have no factual basis, but there is little on methodology. In ways, it is a very dangerous affidavit to simply make assaultive comments that a user did something, purposely deleted a very important phrase, how long to die in the cold, without any forensic data or evaluation or validation. Similarly, when we look at his affidavit, it is replete with accusations suggesting, but never proving, never providing fact, that there was some type of manipulation or tampering with evidence. Now, this is not the role of a forensic examiner unless there is proof, in fact, that happened. Well, when we look through his entire affidavit, we don't see any attachment of raw data. We don't see an updated report. We don't see any viable information.
Do you know what we didn't see from you, Mr. Brennan? An affidavit. You attached a report. Your motion is facially deficient. And you're arguing about the spelling of gray?
That in any way supports his speculative accusations. And so the defense, without having an opportunity for Mr. Green prior to trial, stand behind these statements under oath, would like him simply to come before the jury, make these salacious comments, and then leave it to the government to knock it down. And that might be a common
Oh, come on.
view in the transcripts of this case, but the Commonwealth does not intend to simply let evidence come in that's not qualified, that's not factually sound, and then go knock down glass houses. That is not the approach the government's going to take to this case. Mr. Green's going to testify. He should have a report that is factually based with methodology supporting these claims, these narratives that he's proposing. Considering testing in this case, there are certain tools that are used. The defense wants to propose that there's some type of race that Mr. Green looked at or used more tools than a Commonwealth expert.
He did.
The tool is simply software. A good analogy is that of an X-ray. Anybody can take an X-ray, but it takes an expert then to interpret the X-ray, to interpret the data. In this case, Mr. Green, in his affidavit, proposes that because...
Okay, that could be the worst analogy ever. It's not like an X-ray. It's 5 different kinds of software. Interesting that he just said glass houses, since that's the album name of the Billy Joel song that we were just talking about earlier. You may be right. That's kind of weird.
to use a number of tools, because he has a number of X-rays, that somehow there's significance to it. But what it lacks is a forensic analysis of that information. And it is clear in his affidavit that it lacks that. He cites 2 opinions. His first opinion is based on Cellbrite processing and Axiom processing. I'm not going to go through all the little details that we dispute or go through a technical assault on each point, although that the overall idea of this evidence is why this should be subject to a Lanigan hearing and why we are willing to call our own expert as well, so that the record is clear and the science and data is clear. Instead of doing validation or testing, relying on Cellbrite, what Mr. Green has done in section number 13 of his affidavit is stepped aside from methodology, and instead he cites that he called Cellbrite technical service. Now, this is the forensic examiner who is supposed to go through the process, and yet he defers it to technical support of Cellbrite. Technical support in Cellbrite, he relies on to say that this artifact where this search is stored is appropriate. And he remains standing on that foundation as why somehow there's some validation that this search occurred at 227. But then when he learns that Cellbrite, after actually doing analysis and study and updates and engage in methodology and review, determined that the way that was assessed is unreliable and the program has been updated, which no longer shows the 227 search at 227, and I'll explain why for good reason. I'm sure the court has heard this before. Mr. Green then denounces the very source that he relies on. And so on one hand, he's saying, I relied on technical assistance of Cellbrite, but then when they told me what I didn't like, I can ignore that part.
I just want to point out, again, because we've talked about this 100 times, the purpose of a Daubert or Daubert-Lanigan hearing is to inquire or prove that the expert is qualified as an expert to testify about the things that he's being called to testify about, his opinions or her opinions. Going into the substance of his testimony is improper for a Daubert hearing. It's improper. It should only be about qualifications and whether or not this person is qualified to testify as an expert in the subject for which they are being called. Now he's just going into the substance of it, and it's completely outside the scope, but I'm sure she's going to let him ramble on, and ramble on Rose for as long as he likes.
He then defers to Axiom. Axiom, the government.
And you can cross-examine him about that at trial. But now you're wasting judicial time and resources and defense funds and money to argue this completely hollow and improper argument in your desire for a Daubert hearing.
The defense touts is a separate source that reinforces the same point when clearly it doesn't. You can see in number 14 of Mr. Green's affidavit, he talks about the fact he uses these different programs because he wants to view data. And that gets back to the X-ray analogy. He is viewing data from many different programs that say the same thing, but he never goes on to analyze it. What is troublesome about his affidavit in section 14 is he attempts to use resource material to convince this court that rather than methodology, these summary statements are something that the court should rely on. And so what he does is he takes an excerpt, page 7 of his affidavit, number 14, and he says that the Axiom user manual describing the artifact as follows, that the artifact is in Safari suspended state tabs and then has a last interaction date time and the date and time of the current tab state when it was last interacted with on the local device. And so he's taking a piece of the manual, they don't introduce the manual, and he tries to use that to buttress that this search happened at 227. What you're not offered is that in the Axiom notes, in their artifact reference guide for the description of Safari suspended state tabs, which he's referring to, and this is the death knell, really, for the analogy that the defense tries to make. The Safari suspended tabs contains the current state of each browser tab in Safari that is currently open on the local device. The date and time are only updated when the user interacts with that tab on the local device. Since these are local tab states, results from the artifact may contain an earlier date and time compared to the results in the Safari history artifact if multiple devices on one iCloud account. And so by Axiom itself, it makes clear that an artifact in a tab can reflect a time that is much earlier than the actual search. And this has been presented to the court. We've provided the trial transcripts of Ms. Hyde and Mr. Whiffen. When a tab is open, many tabs can be open. It is open at a particular time. And if that tab is reused, the original time will imprint. And so certainly Mr. Glean knows of the Commonwealth's argument. He knows of the opinions by Mr. Whiffen and Ms. Hyde because he takes shots at them. Or
that's why it's called Battle of the Experts. Your expert doesn't agree with my expert is not a reason to exclude your expert. The difference of opinion is to be expected when you have competing experts. Welcome to trial law, Mr. Brennan.
makes mention of them in his report, and yet he does nothing as far as validation to consider the arguments and dispel them. He does nothing in his affidavit to address the methodology. Quite to the contrary, when you see Mr. Whiffen and Ms. Hyde's reports, it isn't baseless opinions and advocacy of a side. When you look at their reports, it is replete with methodology, fact-based, information-based, the study of the particular device at hand. The contrast between the actual use of methodology that is reflected in Ms. Hyde and Mr. Whiffen's report and this affidavit is so clear. Now, there are two opinions that are proposed pursuant to this affidavit. The first is the claim that how long to die in the cold was somehow inputted at 2:27.
This is not why we're here. We're here to talk about his qualifications to testify as an expert, not about whether his opinions are right or not. I can't even believe this is allowed to continue. It's wild. You guys, you are in the upside down right now. We're there together, and it's a scary place to be.
The only effort that appears in this affidavit by Mr. Green is in section 15, where he did a low-level analysis of the wall file. Now, I am not an expert, and that's why the court should hear
Clearly.
from Ms. Hyde or Mr. Whiffen and Mr. Green. But a simple understanding, wall file can contain information as a repository. And the description or misunderstanding by Mr. Green of the wall file is clear.
The only misunderstanding here is you, because you don't understand what the purpose of a Daubert hearing is.
Here in his affidavit. In fact, he implies that there were 3 searches in his affidavit, number 16.
There were 3 searches.
Let's look at this phone that there were 2.
These suck.
Why
Why does the
his
feed
second
keep freezing?
opinion is an attempt really just to create confusion, to disparage, and to make claims that are factually untrue. It's necessary to have this claim because number 1 doesn't have any resonance. Leaving somewhere, somehow. Not an uncommon.
I'm on Ethernet, so it's not me,
The
it's them.
claim, or the opinion number 2, the defense would like the jury to hear, is that somebody somehow, whether it was a person, presumably the witness in this case, or the police somehow manipulated the phone. I dare say there's no evidence to support that. And yet, in an affidavit under oath to the court, in an attempt of advocacy, this witness is comfortable and willing to promote a claim that has no factual basis. If a witness,
That's an opinion.
is going to promote in an affidavit a claim with no factual basis, we should not trust, without vetting that witness, that their other claims have any merit or value.
You didn't even have an affidavit.
In opinion number 2, this expert, so-called expert, takes the liberty to say that the McCabe cell phone could have been manipulated. Not that it was, not that I did a study, not that I have a fact. It could have been manipulated, then rehashed after manipulation with the PDF.
You know what you don't have the fact of? You can't prove the fact that John O'Keefe was hit by a car, sir. Sir.
Being modified. Wow. It's an extraordinary conspiracy in the world of forensic science to be able to accomplish all of those tasks. So if he has no basis in fact or methodology, no good faith basis to make this assertion, why is he? Why is he? It is because the claims he makes in opinion number 1 are so scientifically and forensically unsound. This is a tactic to confuse the issue. And think about the import of this baseless claim by Mr. Green. It is suggesting that a witness with no other evidence whatsoever was involved in a conspiracy to murder somebody. That's the implication that he wants the jury to be confused by. Otherwise, there'd be no other reason to make the suggestion. That is an extraordinarily harsh claim when you don't have any facts. Now, how could one cause manipulation? There is scientific ways that could be explained how manipulation could occur, but we don't see any of that in this affidavit because it didn't exist in this case, because there was no deletion or manipulation by the witness. There was no manipulation by the.
You also didn't provide the hash values for the first time ever in Mr. Green's storied career. Is the first time ever that a phone extraction was turned over without hash values, sir.
The police who processed this phone. If there was, there would be some proof.
There would be some proof that they
This
manipulated it?
affidavit speaks volumes by the absence of fact and data and science.
Yeah.
Mr. Green does nothing to try to demonstrate that there was user deletion on this phone or that there was manipulation by the police. When you look at the data in the phone, the question arises, why is there a 624 search and not a 623 search? The phone stores the last entry into the tab. It's not just science, it's common sense.
It's common
that Mr.
sense?
Green ignores.
It's common
So
sense. Or
not
now
be-
you're a forensic expert.
Being able to prove user manipulation because it didn't happen. He turns to police manipulation. And he says that there can be a problem where the hashes don't match, but the problem is the hashes do. They match. He complains that he did not receive the PDF when he received the download. And because there was a production at different times, he then sprints out into a different universe and suggests that somehow it must be because there's manipulation.
My head's going to pop off.
And again, doesn't prove it. There's actually ways that a real forensic examiner can look at the PDF, gray key file, and the phone.
Wait,
and
a
determine
real
whether
forensic
manipulation
examiner?
occurred.
Are you now saying he's not a real forensic examiner? Are you saying that your boy, Ian Whiffen, who has testified one time in his life before he testified in the first persecution of Karen, Ian Whiffen from Canada, whose entire testimony was a big, long infomercial for his own RTech software, who happens to be an employee of Celebrite and yet throws Celebrite under the bus during his testimony. Did you just say that hold on, he's not a real forensic expert? I'm taking it back a second.
Doesn't prove it. There's actually ways that a real forensic examiner can look at the PDF, gray key file, and the phone and determine whether manipulation occurred.
No,
There's a
it's
program
supposed to
called-
come in a USB altogether. The data is supposed to come all together. You don't give them a PDF afterwards that could be manipulated. Is he really in good faith making this argument? Because I am in the twilight zone. I am. My head's going to pop off in a minute.
XMP and another one called Magic. The problem was expert witnesses went through that process. No manipulation. But Mr. Green doesn't even go through the process to disprove his own theories. If he used methodology, he could simply dispel his own claims. It's either he doesn't understand the forensic technology to do that.
You're right. He doesn't
Or he
understand.
chooses not to do it so he can just posit hand grenades throughout the case and let them resonate wherever they fall. In an attempt to create some doubt or uncertainty or merit some conspiracy, he lists a number of what he calls anomalies, which are really not anomalies at all. I could go through each one of them. I could give a difference of opinion.
Please don't.
I could show that Mr. Green's anomalies have no basis in fact, but suffice to say, I think this should be done by qualified experts, and that's why there should be a Lanigan hearing. There is such misunderstanding of forensic science in Mr. Green's claims and anomalies. If he's going to make these assertions before it goes before a jury, he should sit in the witness seat under oath, as the Commonwealth witnesses should as well. And he should justify, explain to the court why he did not engage in methodology and how he has come to these extraordinarily baseless, inaccurate, and prejudicial claims.
Prejudicial to who? Prejudicial to who? Jennifer McCabe? Are you Jennifer McCabe's defense attorney? Are you ducking kidding me right now? Prejudicial claims? If you had any doubt at all that Hank Brennan was the defense attorney for Jennifer McCabe, that doubt has just been put to bed. Night, night. Listen.
How he has come to these extraordinarily baseless, inaccurate, and prejudicial claims. The Commonwealth has to, the court rather, has to look at Lanigan and whether or not a hearing is appropriate in this case. When we look at the different non-binding factors of Lanigan. We look at number one, whether it has been generally accepted in the scientific community. The software has been generally accepted in the scientific community. So hasn't the effort of a forensic examiner, the expertise. And the defense complains in their motion, the Commonwealth has not properly addressed the methodology of Mr. Green. Well, the reason why is Mr. Green does not provide any methodology. So this is the way to address the methodology.
Can't wait for Alessi to get
Number
up.
two, the opinions have been or can be subjected to testing. Well, we see Ms. Hyde and Mr. Whiffin's report directly contradict
Hmm.
the assertions, the unsupported assertions of Mr. Green.
That's why you have experts and we have
There
experts,
is no testing.
because they
that his
disagree.
opinions have been subjected to. There is no peer review.
We're in
There's no
purgatory.
other alternative support for his opinions. They're just broad, baseless claims. Number three, has been subjected to peer review and publication. Certainly the science, the forensic science has, the software has, but the interpretation and Mr. Green's interpretations, it hasn't been subjected to anything. In fact, it changes. Has an unacceptably high known or potential rate of error. Well, if we see and read Ms. Hyde, it's just a high level of error. It's gross error. It's total error. It's wrong. And is governed by recognized standards. Well, if you look at the history report that the defense filed as an attachment, it talks about a forensic examiner's obligations to verify, to test things that Mr. Green didn't do. Their own report that they offer in support undermines the idea that Mr. Green did anything to validate or support his opinion. And as we see from both Selbright, he does not follow the protocol. He does not follow Axiom or the guidance that they give him. He sidesteps both of them to give the opinion he wants to advocate for the defense. At every turn, positions of Mr. Green are not only unsupported, they're unverified. So what arises from this subterfuge is that Mr. Green is really just a vessel or an attempted vessel for the defense, third-party public defense. It is not lost on me, I'm not unmindful of the data on the phone being a search Holland Diane call that occurred after 6 a.m. in that morning coincides with first responders' testimony that the defendant herself was asking these very same questions around that time about Mr. O'Keefe and how long he could survive the hold. Under the extraordinary broadness of circumstances and the depth of the amount of witnesses and information in this case, it is hard to think that that just happened by happenstance, that there is a inquiry, something forming in the mind of the accused is then shared with the witness, Ms. McCabe, and in response, she makes the search, which is entirely supported by all the credible forensic evidence. If Mr. Green is going to be witness in front of the jury in light of the fact that he has no methodology and he's wrong on science. In addition to the fact that he wants to now appear as advocate for the defense and accuse everybody and anybody without articulating who, just anybody other than the defense, he should have to stand behind those claims under oath. And so I'm asking for a Lanigan hearing. We are not shying from our burden. We're more than happy to bring in a witness so the court can contrast the two. Thank you.
All right, thank you. Mr. Alessi?
Oh my, this is gonna be great. Buckle up, buttercups. Look at,
Please, the court. Mr. Green is eminently qualified to provide testimony in this case with regard to the subject matter that has been challenged by the prosecution in this case, and that is with regards to the search house long to die in the cold that occurred at 2:27:40 a.m. on January 29th, 2022. Mr. Green, and I want to cover the baseline for this hearing first. Mr. Green testified at the first trial. He testified without objections as to his qualifications. He testified without objections to his methodology. Your Honor sat, obviously presided over that trial. Your Honor did not issue after his testimony any limiting or curative instructions with regard to either his qualifications or methodology, nor did the prosecution after his testimony stand up and ask for any such limitations or qualification. The baseline for his qualifications and methodology was established, again, without objection. And
He's pissed. And someone's phone
But
rang.
they are being challenged
Mrs.
now.
O'Keefe's phone
I
rang.
was
Mrs. O'Keefe's phone rang and she just walked out of the courtroom. If you weren't watching, just come back to your screen for a second.
qualification. The baseline for his qualifications and methodology was
There's
established,
the phone.
again, without objection. And
But they are being challenged now.
I was just waiting, Your Honor. They are being challenged now, but the reason I state that is because what Mr. Green has provided in response to this motion is even more detail than what happened in the first trial. In Mr. Brennan's argument, he did not make one argument about Mr. Green's qualifications. Zero. So I'm assuming, because there's nothing in their motion that even goes into why he might not be qualified. So to me, Your Honor, that's a tacit concession, if not expressed, that he's qualified. And of course, he has to be qualified in digital forensics because there are 5 other areas of digital forensics opinions and methodology that Mr. Green is testifying about that has not been challenged. So to me, it is rather odd right off the jump that there's no challenge to 5 other areas of data forensics, and there's just this challenge to one aspect of this whole testimony and opinions. I have provided Your Honor with 2 exhibits, demonstrative in support of my oral argument. Exhibit 1 is entitled Digital Forensics Methodology Regarding Subject Artifact, and Exhibit 2 is entitled Digital Forensic Product Tools Used by Witnesses. The Commonwealth has agreed to my use of those exhibits. They had some, I agreed to theirs, and I would like to, Your Honor, use those in a moment.
I don't want to rewind, but I missed what the judge said because I was watching Peggy O'Keefe walk out with her phone. Can you guys tell me what she said in the chat?
The Commonwealth, in its oral argument, said 10 times just now that there's no methodology and that Mr. Green does not articulate a methodology. That is incredible to me because the opposition and Mr. Green's affidavit, in fact, are replete with the methodology. And here is the key, Your Honor. While Mr. Brennan challenges the methodology, none of his witnesses, neither Mr. Whiffen nor Ms. Hyde, challenge the methodology. As a matter of fact, in their 2 reports, neither of them even describe Mr. Green's methodology, nor do they challenge it. And of course they can't, because it's the same exact methodology that they use. And that's what I would like to go to now. Exhibit 1 is entitled Digital Forensics Methodology Regarding Subject Artifact, J. McCabe iPhone Data. And I prepared this. This is just what's in our opposition. It's in Mr. Green's affidavit, but it summarizes what the methodology is that we're talking about here. What is that methodology? Step 1, you receive, and this is to answer the question about what is the proper interpretation of the artifact in question that everybody agrees is the artifact. Step 1, receive a full file system image of extracted data from the Commonwealth. For example, the defense received it on a USB thumb drive. That's undisputed. If you look at the reports of Ms. Hyde, you look at the reports of Mr. Whiffen, they all say they received a full file system image of extracted data. So step 1 in the methodology that everybody agrees to, everybody agrees that occurred. Number 2, verify hash signature value of image file of data received. This is very important because hash values with regard to forensic data is extraordinarily important for it to be proper because it's the signature, the fingerprint that allows data forensic examiners to be sure that the data that they're giving is sacrosanct. It is not possible for manipulation. The Commonwealth just said that Mr. Green has hurled several accusations without a basis, one of which regards the potential for manipulation of data. And it's remarkable that there is even an issue about this dispute. Mr. Green did put in his affidavit an unprecedented situation, and it is this. Mr. Garino, Trooper Garino, in his April 2023 report, which is an exhibit to our opposition, states that when he got the phone of Miss McCabe, he used Celebrite UFED, a tool of Celebrite, to image the phone. And that's all he sent to the defense in the beginning. Why is that unusual? Because what happens in every case, without exception, is that the law enforcement sends the raw image, original data that has the hash signature on it. And the hash signature is an algorithm that produces, they call it, in this case, SHA-256. What it is it's a stamp of reliability that says, as soon as we got this data, we immediately processed it the proper way and put a hash signature so that there can be no contest. What the Commonwealth fails to tell the court, Your Honor, is—
Oh, don't fail me now, law and crime. Hold on.
value, and that leads any proper data forensic investigator to question the integrity of the data. If you turn to, Your Honor, Mr. Whiffin's very long December 2024 report, which is Exhibit 1 to the Commonwealth's motion on page 3, and I'm going to read it verbatim.
Good, because we
This
didn't see
value
it.
is talking.
Come on, man. Don't leave us hanging.
Here's the key point. However, this requires authentication of the original hash value, which is not possible with gray key extractions, as the PDF containing the extraction hash value is unsigned. Therefore, this hash value could be used as a suggestion of authentication. That's all a fancy camouflage way of saying, Mr. Whiffen saying, I can't validate this hash value because of the way Trooper Guarino processed it. Do it, Mr. Guarino, Trooper Guarino, the right way when he got it. And why is this of concern? Add to this point that's conceding that the hash value in this data cannot be validated. How did the defense get this? When Mr. Guarino used the Celebrate UFED reader, all he turned over in the beginning was the UFED reader report. He didn't turn over the data, the full. So Mr. Green had to ask for the data. Then what happens, misstep number 2, Trooper Guarino only provides a PDF of the hash value. He used gray key, which was a mistake, because gray key, you can't get the original hash value. Mr. Green had to go back a second time and say, no, we don't want just a PDF. We want the full extraction. Finally, after the second time, the defense got the full extraction. And that's when we discovered that the validation was improper. It's not Mr. Green that is coming up out of thin air with these issues. This is the job of a data forensic person, and the first principle is to see whether the data is valid. So not only does Mr. Green justify in his affidavit why there's a big concern over this, Mr. Whiffen concedes it on page 3 of his report. That starts, and I'm going to get to it, all the concerns now about the data and deletions. But that's the foundation for it, and it wasn't caused by the defense. It was caused by Trooper Guarino, who didn't do this properly.
Mm-hmm.
And with regard to the methodology, I want to go back to Exhibit 1. So, importantly, Your Honor, 1 through 4 of this methodology is undisputed by all of the data forensic persons. Mr. Whiffen, Ms. Hyde, and Mr. Bean all agree on 1 through 4. They all agree that this is the methodology. Number 3, once you get the image of the file, each examiner saves the image to their lab storage system. Some use computer servers, some cloud storage. And for the methodology, you then process the data with appropriate tools. Nobody disputes that Celebrite Physical Analyzer and Magnet Forensic Axiom are two of the many tools that are available to use. There's a dotted line that I've put there, Your Honor, because 1 through 4 is undisputed by all 3 data forensic examiners. Number 5. And 1 through 4 is usually all one needs to do as a data forensic examiner. But Mr. Green went on to do more. Number 5, further processing of data as warranted. And he explains why it's warranted here with additional tools. So he then went on to use Sanderson Forensic Browser, ArtX, Belkasoft X, and then he didn't use iLeap. Ms. Hyde used iLeap. So it's important to line up the methodology. I just don't understand how it can be stated that there's no methodology stated. Not only does Mr. Green state it, we prove undisputed that everybody agrees this is what the methodology is. And that is what is so flummoxing as to why we're even here, because the methodology is agreed upon. What is disputed, Your Honor, is what are the opinions from when you apply the methodology and you apply these tools. So, interestingly, it is Mr. Whiffen who provided the most lengthy report in this motion. Mr. Whiffen only used 2 forensic tools. He only used Celebrite Physical Analyzer and his own software, ArtX. That's it. What I'd like to, Your Honor, is ask if I could, please, if you could turn to Exhibit 2, which is entitled Digital Forensics Products Tools Used by Witnesses. And I just want to make sure Your Honor has that.
Turn to the page, Your Honor.
Okay.
So I prepared this demonstrative exhibit to show the tools that all parties used. And the purpose of this is to show how closely Mr. Green and Ms. Hyde match up with the tools used and how insufficient Mr. Whiffen and Mr. Garino are. So if you look at the left-hand column on Mr. Green, and I color-coded it to try to make it easier, you see 7 tools used by Mr. Green. You see 6 tools used by Ms. Hyde in May of 2023. Many of the same are, many of her tools, exact same as Mr. Green. You see Mr. Whiffen, who used really 2 tools, but to be conservative, I listed them as 3 because they're just different versions of Celebrite Physical Analyzer. And then Mr. Garino, Trooper Garino, used 2 tools. But here's what's really important and I think remarkable that springs from this chart.
He made a chart for her that was so
Mr.
nice.
Green did more, had a more encompassing and comprehensive review than any of the witnesses here. And back to Exhibit 1, he did 2 more steps in his methodology than everyone else. So 1 through 5 of the methodology, everybody did. 6 is analyze overall user activity, artifacts of interest, timelines of interest, and anomalies such as deleted data. 7, reporting as appropriate pertinent artifacts, other artifacts. For this motion, Mr. Green did 6 and 7, and no other witness did that. The issue in this case as to whose interpretation is correct is an opinion issue. It is not a methodology issue. And Mr. Green makes that very, very clear in his affidavit that the difference is in opinions. Interestingly, on the very key subject of whether the artifact and the interpretation of it is a difference in methodology, a difference in application of methodology, or an opinion, which is not the subject of a Daubert-Lanigan hearing. Opinions are not.
Praise
Here's
be.
what Mr. Whiffen had to say about the issue. This is Exhibit 2 to our opposition. It's the June 17, 2024 testimony of Mr. Whiffen, page 1-10, starting on lines 14, the question. And what, if anything, did you find with regard to the web history artifacts? Answer, this is Mr. Whiffen. So the 2/27/40 timestamp was correct insofar as that is the time that is shown within the database. It was indeed a deleted record. But the interesting thing was why the timestamp said 2/27/40. And I did some testing on this and discovered the reason why 2/27/40 was actually listed in the database, even though that's not the time. Here's the key, in my opinion, that the search was conducted. So Mr. Green's opinion is, after applying the methodology that everybody agrees to, after using the same tools as every other witness for the Commonwealth used plus more, Mr. Green's opinion is, to a reasonable degree of scientific certainty, that that search and that record that everybody saw at the time of trial at 2/27/40, House Long to Die in the Cold, Mr. Green says it means what it says. The search occurred at that time. Now, the Commonwealth, in its recent reports, and they did this also at trial, they said, yeah, we see it, it's in there. Ms. Hyde said, I see it. It's not only in there in Celebrite Physical Analyzer. I used Axiom, just like Mr. Reed. Mr. Whiffen didn't use Axiom. Ms. Hyde said, and I'm going to point to it specifically, Axiom shows it as a 220, that search is a 224. In fairness to trying to get the best decision for Your Honor here, they disagreed, Mr. Whiffen and Ms. Hyde, as to whether that meant the search actually occurred at 2/27/40. That's the opinion that's disputed. So in fairness to the issue and accuracy, those witnesses diverted at the end as to whether what that timestamp showed, 2/27/40 a.m., did the search really occur then, or as the Commonwealth said, did it occur at 6:23 in the morning? Mr. Whiffen says it's a difference of opinion because he says it's my opinion. The Commonwealth in this motion tries to make it seem like it's an issue of fact and that Mr. Green doesn't have any fact. Well, Mr. Green's got a lot of facts, and he also, of course, has an opinion.
Thanks, Chip.
So what we have from these two demonstrative exhibits, Your Honor, is a statement of the methodology in Exhibit 1 that every witness agrees to. Not only is it Mr. Green put a methodology, but we prove up in the opposition that there's no dispute. What's interesting, Your Honor, and I think quite remarkable, is that neither Mr. Whiffen in his 40-plus page report of December 24, nor Ms. Hyde in her December 24 4-page report, neither one of them say Mr. Green's doesn't have a methodology. They don't say we dispute his methodology. It's the Commonwealth's attorneys that are making that dispute. And that is not appropriate. It's got to be your expert. And I think there's a reason why the experts of the Commonwealth are not talking about methodologies or saying there's a dispute, because it's objectively verifiable that there's not a dispute over the methodology. What is also important is what has happened since the trial. And what I want to do is give a baseline of the trial, because I think it underscores the two issues that Your Honor have in front of you: qualifications and methodology. And the qualifications, all I'm going to say about that is Mr. Green has 25 years of experience in computer forensics, and he has 18 years in digital forensics. And the 18 is only because digital forensics became a thing 18 years old. There can be no dispute, and I think that's why the Commonwealth didn't really say anything about it, is because if you lay down Mr. Green's experience next to Mr. Whiffen, Mr. Green testified 23 times as a qualified digital forensic expert in 7 different states. Mr. Whiffen, he's testified in 2 states, one of which was here, and he does not have anywhere near the years of experience. Here's another very important point: certifications. Mr. Green lists 3 certifications. He lists an enormous amount of constant updating. And I just want to state a point about digital forensic experts. They're not like medical doctors where you see people with PhDs, etc. These are folks that keep updated because the computers change so much. So that's why you see such a great listing of Mr. Green in terms of his training and certificates, etc. However, if you compare Mr. Whiffen's qualifications to Mr. Green, and I'm again going to use Mr. Whiffen's own words with regard to his qualifications on his June 7th, this is again Exhibit 2 to our opposition, his June 17th trial testimony, page 1-6. Question, and this is a question from Mr. Lau. Now, with regard to your education in this area, what, if any, certifications do you have? Answer, no specific certifications. I've done the Celebrite coursework since joining Celebrite, but other than the 3-week course in Ottawa, and then again, the 2-week course in Ottawa, those are police training things when he's a policeman. I don't have the SANS training or any of that kind of training certifications. Now, I am not here today to challenge Mr. Whiffen's qualifications.
Not today. Not today. I told you they'd be moving to challenge his qualifications.
But how could it possibly be asserted that Mr. Green's not qualified if these are the qualifications of Mr. Whiffen? With regard to what has changed since the first trial, and I think this is incredibly important with regard to the methodology inquiry of Your Honor. I went through on Exhibit 1 the methodology that everybody agrees to. But the court doesn't have to take my word for it on this demonstrative exhibit, because Ms. Hyde gives the best explication of the methodology that Mr. Green used, because she used the same one before trial and at trial, but she's now narrowed it for purposes of a report, and I'm going to state and show exactly how. So Exhibit 4 to our opposition, Your Honor, is the May 2023 Digital Forensics Analysis Report of Jessica Hyde. And in that report, on page 3, she talks about, under forensic analysis, that she used, it's the exact same methodology.
What are you, I thought you said Exhibit 4. Exhibit 4 is a transcript. It's a transcript of Ms. Hyde, but it's not a report.
Okay, my fault, we had different numbering, but I'll go to the transcript. I'm going to go to the transcript with regard to it. So
I'm happy to look at the report if that's what you're referencing.
I'm
but
going
where
to
do I
go to the
find
report
it?
next, but if Your Honor's already at the, I can do it either way.
Yeah, because he can pivot on his feet. Thank you, Decline, for your super sticker.
If Your Honor is at the transcript, I'll go to the transcript right now. This is the June 14th transcript, Your Honor, of Jessica Hyde.
Yes.
Thank you. So
Thank you. Thanks,
just-
Petty.
And please keep in mind that in Mr. Hyde's 2024 report, that Mr. Whiffin's report that is now before you, Mr. Whiffin only used in his analysis now Celebrite Physical Analyzer and Ardex, his own tool. He only used 2 tools. Ms. Hyde, in her 2024 report, which I will get to, is now down to just using 1 tool, Celebrite Physical Analyzer, because she states that's the only one I was asked to look at. So the Commonwealth went and narrowed the request of Ms. Hyde to just Celebrite Physical Analyzer.
Wow.
And what is going on here? It's very obvious. The Commonwealth is ignoring in its 2024 December reports all the other tools. Even though those tools show this timestamp of 2/27/40 still, at that time, they now just ignore it and go to the Celebrite Physical Analyzer. That it's undisputed that Celebrite went back and changed it in the middle of the first trial with regard to one physical analyzer program. And then after the trial, the other physical analyzer program, they went and changed that and took it off. But in contrast, Axiom that Ms. Hyde used before still shows the timestamp. It's undisputed that that's the case. And it's undisputed because they don't contest it that Mr. Green went and looked at it in Belkasoft, Sanderson. He did a manual, he did a low-level analysis, and in every one of those tools, the timestamp still occurs. So now back to the transcript. Your Honor, I am looking at, the question of, and this is, again, a significant point, is it better to use more tools? It's common sense. That's what Mr. Green says. That's what Ms. Hyde did the first time, but now all of a sudden she's down to just 1 tool that unilaterally removed the timestamp. So here is the page of the transcript of what Ms. Hyde had to say. Page 1-13, Your Honor.
Okay. They told her to
Line
only
4.
use Celebrate
Question,
now.
Again, of Mr. Lally. Now, with reference to the tools that you use that you just went through, are those fairly common tools? Are those tools that are commonly used within your industry? Answer, yes. And what are those tools that she talks about above? Starts on page 1-2. Celebrite Physical Analyzer, Magnet Axiom, Artex, iLeap, and I later used Sanderson Forensic SQLite. Those are 4 of the tools that Mr. Green used, and he used more. So her answer is, now with reference to the tools, are those tools that are commonly used within your industry? Answer, yes. They are commonly used digital forensic tools that are very standard for other forensic examiners to use on mobile exploitation. It gets better for the defense. Next question, line 15. So different forensic tools, question, and why were you using the different tools? So different forensic tools have different capabilities and look at data a little bit differently. Skip down. Commercial forensic tools that they can only support so many applications, so they each work and support different bits of data. Here's the key point, line 22. This is Ms. Hyde's words, under oath. So it's important to use multiple tools so you can see the results from different tables, different data sets, and be able to compare those results and enhance those with manual analysis. Next page. Question, and with respect to, and this will be the last question and answer, and with respect to using those sort of different variety of tools, Celebrite to Axiom to Artex, etc., is that something you typically do as far as your normal process of documenting a forensic analysis? Answer. Yeah, that is very, very typical for me to process with multiple tools to ensure that I'm getting the most complete interpretations from forensic tools. Of course, you go beyond that with your analysis, but it's absolutely pertinent. And down below, he asked, can you explain the interplay of these tools in analysis? And her answer is strikingly the same as Mr. Green in his affidavit and in our opposition. Her answer, the Sanderson's tool, which Mr. Green and Ms. Hyde used, but Mr. Whiffen didn't, is meant to look at specific type of data structures called the SQLite database. SQLite databases are very nuanced, and this particular tool allows you to take that database and explore it at a deeper level than the other forensic tools allow. Mr. Whiffen didn't use the Sanderson tool. So here we have Ms. Hyde, and in her report of 5/23/2024, her first report, and I'm going to get to her report here, she basically goes through and documents this methodology, and she documents the use of those tools. And she also documents that she saw the House Long to Die timestamp 22740 in every single tool that she used. Where she diverted from Mr. Green was her opinion as to whether that timestamp meant the search occurred at that time or did it occur sometime later. That's an opinion issue again, and Mr. Whiffen agrees in its opinion issue in that regard. So now let's come to where we are for this motion and what was submitted by the Commonwealth. And I want to first go to the report of Ms. Hyde now. It's Exhibit 4 to the Commonwealth's motion. And it's entitled Digital Forensics Analysis Report. And there's been much said in the Commonwealth's argument this morning about allegations made by Mr. Green, which are all supported. Every single one supported with facts. But what the Commonwealth didn't tell the court is what the request was of Ms. Hyde. I just went through all the tools she used, why she used them, why she said it's best practices, why you use all these tools. What does she do now in December of 2024 to assist in the myopic approach of the Commonwealth to say, here's our studies, we only look at Cellebrite Physical Analyzer, and it's gone, the search is gone, right? And we know why it's gone, because Cellebrite, Mr. Whiffen, concedes that he went back and talked to the researchers, and what we have, Your Honor, is a total black box. And I'm going to point it out in a moment. Why is this no longer appearing on Cellebrite Physical Analyzer? We don't know the answer. All that is stated is a bald conclusory statement that it's no longer reliable. That's it. We don't know why it's no longer reliable, but we know it's gone. And Mr. Whiffen never says, even though it's gone in one, he doesn't even address the other 4 or 5 tools where it still appears.
Right.
It still appears. Now to Ms. Hyde. Disquietingly, on page 3, look at the request, please.
Disquietingly. Oh, you gotta love it. Cat's meow. Yes, we are. We are definitely still. We are in bizarro world again. Thanks for your super chat.
The request was to understand changes made in newer versions of Cellebrite Physical Analyzer to artifacts pertaining to the timeline of a Google search on January 29, 2022, namely House Long to Die in Cold. That is stunning. The request to her was simply to look at one tool that everybody knew by then Cellebrite had deleted in their program. She then looks at evidence analyzed, second paragraph. This full file system image was processed with Cellebrite Physical Analyzer, version blah, 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 decoding engine, etc. Where is her analysis of Axiom that was in her May 2023 report?
It magically
Where is
disappeared.
her analysis of Sanderson? Where is her other analysis that if she went and did it, she would have to say it's still there?
Well, that's a rhetorical question because it just magically disappeared like everything else in this case, like all the video.
So what she goes on to say is very interesting, but it's buried, and here's what it is on page 4. After she goes through and states what everybody knows is Celebrate just went back and for some reason deleted it, she says under the chart, while manual analysis of the database still shows a 22740 AMET timestamp, the determination in prior analyses and from Celebrate is that this timestamp does not demonstrate that the URL was visited at the time of the last visit timestamp. So here she did a manual analysis and it still shows up.
Yep.
But she doesn't explain the significance of that. If we want to talk about reliability, Your Honor, the real question should be the reliability of the prosecution's witnesses in Celebrate physical analyzing.
So are you telling me that we should have a hearing?
Your
No.
Honor, there's no need to have a hearing, and here's why.
She's insane.
There's no need for a hearing because there's no disagreement on the Daubert issues. The dispute over what is the interpretation of this data, what are the people's opinions, is never one for Daubert. If that were the case, there'd be a Daubert hearing on every expert.
That's right.
Because experts, almost by definition on each side, disagree on the opinions. We don't need a hearing, Your Honor, because they agree on the methodology. They agree that more tools are better. They agree that the difference is at the very end of the analysis, which is the opinion. So in terms of the issues with regard to Mr. Green's report, which is my final point to get to, there's been so many mischaracterizations by the Commonwealth this morning of what Mr. Green did and what he said. So what does he do? He says, and Your Honor, digital forensic analysts are the equivalent of a medical examiner. Their job is to apply the methodology that is agreed to. Their job is to use the tools, everybody agrees on it, and then they're to give opinions on what those mean. And everybody here has the same data, right? Everyone's got the same data that they're using, so there's no dispute over that. The Commonwealth said that there's no factual basis for what Mr. Green did. There's a factual basis for everything, and it's undisputed. So everyone has the same data, and this I call the MB postulate. And the MB postulate is, why are people using different tools, etc.? Is because nobody has the source code for the Apple phones. So you use these tools to try to help interpret what these source codes mean. And it's an accepted methodology to do it. But the data, once it's produced, and we have an issue about what happened before it got produced, but in terms of the methodology that was applied here in the tools, there is no disagreement. So what, Your Honor, would an evidentiary hearing do?
Right.
We're just going to come in and have witnesses talk about their difference of opinion? That's not what a Daubert is for. There's no basis for an evidentiary hearing because there's no dispute over the methodology. I've done a lot of Daubert hearings. I've never even gotten past a motion, let alone an evidentiary hearing, where the experts don't disagree on the methodology. So what is it that caused Mr. Green to raise questions? And again, I said data forensic examiners are just like the medical examiners. They don't look at just the body of the medical examiner. They look at circumstances surrounding it and all information. Well, that's what digital forensic examiners do, and that's what Mr. Green did. So there was great criticism of Mr. Green from doing what is proper for a digital forensic person. And it's a bit of a camouflage, respectfully, because the December 2024 reports of the Commonwealth now myopically go down to just one tool. So what did Mr. Green say that caused him to say, I think it strongly suggests that there's been manipulation here? He used the fact that there's no hash value for the data. That's conceded. And when there's a issue over hash value, every single digital forensic expert is going to raise concerns about the validity of the data. And Mr. Whiffen is one of them who did that.
Yep.
Secondly, what Mr. Green pointed out on the issue of was this search deleted, there were 4,056 searches on the phone.
No,
of
65,
Ms.
I think.
McCabe.
4,000.
4,056. There was one deletion out of 4,056, and guess which one it was? House long to die in the cold.
Mic drop.
There are no odds that that can happen randomly, that one search out of 4,056 is deleted. So what does Mr. Green say? He says that strongly suggests one of two things. Either there was user interaction deletion, or there was post-imaging manipulation of the data. He doesn't accuse individuals. He says user interaction or post-imaging. That is the job of a digital forensic person, to point that out and say that raises concern. The fact that there's only one deletion of a search out of 4,056, I think it's malpractice if a digital forensic examiner doesn't point that out. Another key thing he points out is an anomaly. The Commonwealth said there was a tab number for Hockomock Sports.
Yeah.
In that they said it was the same tab number for how long to search or how long to die in the cold. But Mr. Green points out that's incorrect. They had two different tab numbers. So that theory of the prosecution can't be right. So Mr. Green wasn't hurling accusations. He was doing what data forensic examiners do, is pointing out all these anomalies. These aren't things you normally see, and they're not explainable. Here's the last point I'll make, which there's also agreement. There's this deletion of this one search. Mr. Whiffen can't explain why. He says, well, maybe it was a spontaneous deletion. There's no such thing in data forensics as spontaneous, and he doesn't cite any. Maybe it's because the search didn't load. Maybe it's because there was bad connectivity at where this search occurred.
It wasn't.
Well, that's interesting because a harder thing to load, the image that came up with food did load.
How long did
So
digest
it's,
food?
you got to have stronger connectivity to get an image that dense. So what Mr. Green simply points out is that doesn't make any sense either. That is the essence of Mr. Green's affidavit. And Your Honor, just to be clear, when we sent in the second affidavit of Mr. Green, we put in the cover, and Your Honor may not have gotten this, that it was to replace the first affidavit because there were some typos, et cetera, et cetera. So you'll see two dates of the affidavits, and it's the later date, and I'm going to give you the specific one that controls.
No, I have both.
Okay, right, yeah.
The second one on the body of it does not say it's a supplemental or anything. If it was in the cover letter, that's what, they're both docketed, so they'll both
I
remain
was just going to
docketed.
say, we wanted to have them both there for whatever purpose Your Honor wanted, but there's been some question about why two, and it's a simple explanation, one supersedes the other. So Your Honor, in terms of, and this will be the concluding part of my remarks. In terms of the allegation that Mr. Green relies upon technical support at Axiom, and he relies upon technical support of Axiom, and the statement that is just remarkable, that that's the basis for his expertise. Mr. Green makes very clear that he did his own analysis. He used the tools himself, but here's why he called Celebrate. At the time of trial, Celebrite had two versions of physical analyzer on the market at the same time. One physical analyzer set showed the 22740 timestamp. It showed it, and it showed it in a deleted state. But the recent one, the one that Celebrite updated 1 week before trial, that was the Insights, spelled oddly, INSYETES. That didn't have it. So Mr. Whiffen, or excuse me, Mr. Green did what any good digital forensic person would do. He called up support and said, well, you know, what's going on here? You got one that shows it, you got one that doesn't. But he did what the NIST standards, the National Institute of Standards, and that's attached to Mr. Green's affidavit, says that good digital examiners use multiple tools, and when they have questions or they see anomalies, you call up the program people, you talk to their technical support. That's not someone inexperienced and relying upon them. That is the proper methodology. So Mr. Green did that to corroborate and get explanation for what he found. So in sum, Your Honor, here is what is before the court and what is pertinent for this motion. What is pertinent is the inquiry under Polk, which Your Honor cited in your decision on Dr. Russell. It comes down to, is Mr. Green qualified? There's not even a contest. Second, is his methodology reliable? And Your Honor, those are the only two subjects that are ever proper for a Daubert hearing. Why would we have what will be a very long hearing? Now, Mr. Brennan suggests bringing in Mr. Whiffen. I've never heard of that happening in a Daubert hearing, where one party challenges the witness of the other, and then says, and oh, by the way, I want to bring in my witness to show. That never happens in Daubert. It's the person who.
I wouldn't say never.
Well,
I wouldn't say
wouldn't
never, yes,
take
because
that
we're
back.
in the,
Good point. I won't say never. It is so unusual
because we're in the land of the upside down, twilight zone, lunatic fringe.
to have that happen under these circumstances. And this is the key, Your Honor. Why would we have a hearing about whether his methodology is proper and reliable if all of the witnesses agree what the methodology is? So, Your Honor, in conclusion, I would urge the court to deny the motion of the Commonwealth to exclude Mr. Green on one of 6 data forensic issues. He's going to be testifying, obviously, at this trial. And I would urge Your Honor to not have the evidentiary hearing, because Your Honor has before you everything Your Honor needs to perform the gatekeeping function.
Gatekeeping, she
And
loves that.
Again, it's almost all undisputed with exception of one thing, and that's the opinions of the expert, which is never proper. I will respectfully state that never is appropriate for a Daubert hearing. Thank you, Your Honor.
Right.
Okay, any follow-up, Mr. Brennan?
I do.
Oh, boy.
A little bit of knowledge of
Hold on. I just want to break for 1 second to say, we did it. We did it. We hit 75K. Amazing. Thank you guys. Thank you guys. I could not do this without you. You guys are amazing. Woo, woo, woo. Pop the champagne. All right, get back to Brennan now.
forensic data analysis can be dangerous. So when you hear represent
Wait, what can be dangerous? Hold on. It says forensic gator analysis, like alligator. Hold on. Don't rely on the closed captions.
a little bit of knowledge of forensic data analysis can be dangerous. So when you hear representations or arguments that Mr. Whiffen's opinion that there may have been a connectivity issue is undermined because there was a picture of food which is suggested through a application search, misunderstands the basic premise that that's a cache picture. And that is meant for the user of a phone, for the user experience. And so there is cached items that are available without connection that register and come up quicker from a different source while it's waiting for a search to be conducted.
Why don't you just be the
It's
expert?
simple, it can be explained, it's science, it's data. So when you take a little bit of data and you twist it because you misunderstand it or you want to advocate, that is the danger, and that's why it's best left to experts. What the defense apparently is mistaken about is that using a number of tools does not substitute for methodology. You can use one tool, you can use 30 tools. They're all going to say on the timestamp that how long to die in the code occurred at 2:27 on that browser. That is the time that was opened. That window was opened at 2:27.
You
You
wrong.
can't just look at
You
8 different
wrong.
tools that are all going to say the timestamp is the same. You have to look into the data and into the databases, knowledge C, the history, and you have to
The data don't lie. The people do.
determine what artifacts exist to show that occurred at that time. And when you do that in this process, it is clear that 2:27 search happened after 6 a.m. in the morning. And so that's what Mr. Green doesn't do. He doesn't engage in methodology at all. There's an agreed methodology. He doesn't use it. The defense points to Ms. Hyde's report, how it's narrow. It's narrow because it's an addition to her 2023 report. Mr. Green has not written a report. He has not provided data. He has not provided that he has used methodology. He has not engaged in the process of studying the data. He made a couple of phone calls.
He made a couple of phone
so you
calls.
can't
Hey,
simply
you know what
look at
else
the
happened,
time.
Hanky? You know what else happened? Your expert, Ian Whippen, emailed him in the middle of the trial to try and get him to change his opinion. They didn't even bring that up. He made a couple of phone calls? Really? You think that's how he came to his analysis? By making a couple of phone calls? Dude, you are so disingenuous right now that it's mind-numbing.
Stamp and then give a reckless opinion not based on the methodology. We still haven't seen a report from
Please
Mr.
show
Green. There isn't. Because if he actually does the testing and takes a phone and tested his hypothesis, he would dispel his own hypothesis.
Right.
And if he doesn't do that, we'll do that for him. There is no hashtag concern. And when the defense raises
Okay, it's a hash value, not a hashtag, first of all. So despite the fact that you've been trying to convince all of us that you are now the expert, it's a hash value. There is a concern. He has never in his 30 years of experience ever been provided with a forensic extraction of a cell phone without hash values, sir, brother counsel.
and if he doesn't do that, we'll do that for him. There is no hashtag concern. And when the defense raises issues, postures, ideas, we never hear what the problem is. What is the hashtag value? Who manipulated it? And that is the MO. Blame anybody, don't articulate who. Be like a ghost, evasive as possible, and then when it gets
A
knocked down,
ghost.
just posit a new theory. The government offers to bring in Jessica Hyde next week or in with them at another time. Is it common? No, it's not. It's because the government has no fear of a hearing to help educate the court on.
If you had no fear, you would not be here today. If you had no fear about this 2:27 a.m. Google search, Haas long to die in cold, you would not be disputing Richard Green's opinion on that, only that one issue, because the 5 other opinions he gives on other topics, you're okay with. It is only the 2:27 search of Jennifer McCabe's cell phone, Haas long to die in cold, that destroys your case. And that is the only reason that you are here in defense of Jennifer McCabe, and you know it.
Not. It's because the government has no fear of a hearing to help educate the court on the data science.
Oh, now you want
that
to
is at
educate the
play.
court. Now you want to educate the court. Who's giving you your marching orders?
And so while we don't need to, we have no reluctance to. So there is a real accuracy on the fallacies that Mr. Green promotes in this case.
Wants to
And so
educate the
we're happy
court.
to do it. We welcome it.
Okay. Did you want to say anything very briefly, Mr. Alessi?
In 60 seconds or less, Your
Okay.
Honor. Thank you for the opportunity.
Think she's going to rule today?
The Commonwealth said a little knowledge is dangerous. I don't know what a hashtag is. I've never heard of what was just said as a hashtag. It's a hash value, and it's a very important concept to get
Stop,
right.
stop, stop. Look at Misty Yannetti's face. Hold on. Come back to your screen. Not if you're driving, but if you're cooking or rage crocheting or rage cleaning, watch David Yannetti's face. May have to zoom in on
I
that.
don't know what a hashtag is. I've never heard of what was just said as a hashtag. It's a hash value, and it's a very
Oh, my freeze game is on point. He's cracking up. I'm here for it.
important concept to get right. With regard to the whole premise and point of my argument, Your Honor, that this is a difference of opinions, it was just made by the Commonwealth for me. What was said, it's alleged that Mr. Green has reckless opinions. My point exactly, take away the reckless. They're going after his opinions, and it's been stated now by the Commonwealth itself. It's the opinions, and those are not proper.
That's
for a
right.
Daubert hearing.
You
Thank
go,
you,
bro.
Your
You go.
All right. Well,
There are 4 exhibits that have been marked.
thank you. So it sounds a lot like it may just be a disagreement in opinions,
That's
but
exactly what it is.
for the Commonwealth, I will look more closely at your methodology arguments that were made today. If I decide that we need a hearing, an evidentiary hearing, and that I cannot decide this motion based on everything before me, I will let you know no later than Monday. Okay?
Wow. She
So
can't even
we'll
decide
keep
from the
next
bench.
week, and I'll let you know. All right. So, and not that I
Wow.
would exclude
Thanks,
something
Cheryl.
simply because it takes a lot of time, but we really need to make sure we keep this case on track for the April 1st trial. So I have a question for the Commonwealth on where we stand in discovery. And then we're going to talk a little bit about the motion to recover expert.
Well, isn't April Fool's Day an appropriate time to start this trial? Someone asked earlier, April 1st, if the trial's supposed to go April 1st, when does jury selection start? That is when jury selection would start, is April 1st. April Fool's Day, go figure. Today is what, Friday? She's gonna let them know no later than Monday. I have 4 new filings that we will go over after this hearing is done. So stick around because we're just getting started. So she's going to let them know by Monday, which means that they will need to fly in Richard Green from, I think he's in Florida, for a hearing. They have reserved the two days next week just in case they needed them. And those days are the 6th and 7th, which is Thursday, Friday. So, take your time. You want to keep this case on track, but how about maybe you rule from the bench? Because for every single lawyer who is listening here, who practices law within the United States, there is no reason and no legal basis to have a Daubert hearing on Richard Green when there is nothing but a difference of opinion here. He is far more qualified as an expert than Ian Whiffen. This is a joke, but again, here we are in the upside down world of Norfolk County, Massachusetts. Welcome.
Related expenses.
Your Honor, we've been producing discovery as we've gone along to try to give the defense as much notice as we can. I had anticipated having discovery finished last week. We've sent over most of our discovery last night, or is in the process of being turned over. There was one further report. We've retained Dr. Wilkes as a neurologist. I'm waiting for his report. He's away.
Dr. Wilkes?
And so my expectation is I can have that report by Wednesday.
Okay.
Further, there was a witness interview earlier in the week. I'll have that report
Of
as
who?
well. My Rule 14 commitments are ongoing. They are involved. Enormous amount of time over the months has been spent trying to satisfy that I can account for all the discovery and make sure the defense gets everything that I can as soon as I learn about it. We'll continue to investigate this case all the way to trial, but our discovery should be completed by Wednesday.
Does that include
You're still investigating the case? You're still investigating the case, and you have a new witness that you just interviewed last week, and you're bringing in a neurologist. That's interesting.
the analysis of the data from the Lexus?
That has all been turned over, or we're sending it over on link. It's something like 8 gigabytes on my expert, so it takes a long time to download. It was all sent to us yesterday, and it's all included.
All right,
The
so
analysis
Is it gigabits or gigabytes? I just want to take that back. They've got the information on the telematics system from the Lexus, so hang on. They're sending it over by link.
the data from the Lexus.
that has all been turned over, or we're sending it over on link. It's something like 8 gigabytes on my expert, so it takes a long time to download. It was all sent to us yesterday, and it's all included.
All right,
It's
so
a long time to
Done.
download because you're using computers from 1980 and you just got Wi-Fi in the courtroom and air conditioning like right before this trial started.
Passing reconstruction is done. Mr. Crosby, with expertise in bites and dog bites, his reports are in. Ms. Hyde and Mr. Whitman have further reports that have been provided. Ms. Hyde has one more that's outstanding. We may have it. I expected it last night. I have not reviewed. And I think that accounts for,
I could hear somebody whispering in the mic.
we've been through the entire amount of discovery that was prior. It has all been base numbers. It hadn't been before, and it's marked as previously provided. I've made a very, very thorough accounting analysis with help of all of the information that isn't in those base numbers, and provided everything that I've come across as soon as I come across it.
all right.
Continue to look through all of our materials. There was an issue regarding a phone that we hired a third party to look through the phone and produce all Rule 14 discovery. I mentioned that my position was it was a very broad view that the assessor should look at. I was uncomfortable reporting to the court that the phone had been reviewed by somebody else, so I did it myself.
What?
And so I've gone through the
Wait.
entire phone, every email, every page, thousands.
Whose phone? He went through whose phone? Is this something he was supposed to get a taint team for, like Proctor's phone? He was uncomfortable having a third party look at it. Hang on. I gotta take this back. We hired a third party to look for, is he talking about Proctor? Wait a second.
It hadn't been before, and it's marked as previously provided. I've made a very, very thorough accounting analysis with help of all of the information that isn't in those base numbers, and provided everything that I've come across as soon as I come across it.
All right.
Continue to look through all of our materials. There was an issue regarding a phone that we hired a third party to look through the phone.
Maybe it's Michael Morrissey's phone, the district attorney's phone. Interesting.
And produce all Rule 14 discovery. I mentioned that my position was it was a very broad view that the assessor should look at. I was uncomfortable reporting to the court that the phone had been reviewed by somebody else, so I did it myself. And so I've gone through the entire phone, every email, every page, thousands, and I've provided not only Rule 14, but broad discovery. This went to a protective order this morning to the defense, so they have anything that, from my perspective, from my experience, would be remotely important or interesting to them. Also, I've gone through well beyond my obligation emails of members of the district attorney's office, and that continues, and I have another production as well. I wouldn't call it Rule 14 because it's not necessarily statements of witnesses, but again, I've taken a very, very liberal and broad view of what I would potentially want if I was defending a case. And I've provided that again on the seal today.
Oh, so you're going to base it on what you would want if you were defending a case? That's not the way it works when you're the prosecutor. You need to turn it all over. Not just what you would want if you were defending the case. Yeah, it should have gone to a taint team. Thank you. Thank you. he didn't feel comfortable having a taint team look at it. I can't wait to hear the response to this from Ms. Yannetti or Jackson or whoever's going to get up next.
All right.
And so we do not have an official discovery order, but I'd like the defense to have the discovery meet 30 days after I complete mine, which will be next week.
Okay.
We filed, but I did not see on the docket, or we sent in, we did not file a motion for clarification, and Your Honor did not mention that. That's an important notice that we had sent in, because I am greatly respecting the April 1st trial date, and there's work to be done. And so I would like to address that motion to clarify when appropriate with the court.
Okay.
Oh, okay. Yeah,
Yeah,
Fox
I'll
starting
need
the
some
hen
time
house.
to review this, obviously.
Yes, Your Honor.
Okay. All right. That's great. So the Commonwealth expects to be ready for trial April 1st.
Yes,
Not
we
a-
do.
Okay.
Not if there's no decision
right.
from the SJC on
So-
the appeal, Your Honor.
Now let's just take a look at a preview, if you will, of the defendant's motion to recover expert-related expenses from the Commonwealth.
Oh, look at Alan Jackson's
Okay.
face.
I see there's a written opposition that I just received.
So did I.
We're not going to hear this motion today because I didn't have the opposition. But one of the things that I'm hoping you can tell me before we hear this, all right, there are a couple of things. Let me just, in this motion, there's a footnote that references, so this motion from the Commonwealth was filed, from the defendant, was filed on January 23rd. So more than a week ago, in the motion, I believe, is a footnote that highlights a pending motion to dismiss.
Not
I need that
pending.
motion to dismiss. We
Not-
need to get this
It's not pending yet. They said they were going to make it.
moving. When will that, well, I'd like that filed next week so we can hear it next week.
The reason that we haven't finalized it, the reason we haven't put the full contours on that motion is because we haven't received all the discovery. I
Mhm.
think it would be premature for us to figure out exactly
Right.
what the parameters of our motion to dismiss are until we know exactly what the Commonwealth is putting in front of us in terms of the second trial.
That's right.
But as soon as we get that, we think that we have the grounds to bring that motion relatively quickly thereafter.
So you expect to have everything to the defendants by Wednesday?
I do, and really what's missing is a report from a neurologist, a witness interview that is really inconsequential. And
If it's inconsequential, why did you need the witness interview? What witness magically appeared all of a sudden?
Ms. Hyde has a report regarding a phone. That's all that's really left for discovery. So that's all.
And the 8 gigabytes that you may or may not
So
have
if
turned
you
over
get
yet.
it by Wednesday, we're here Thursday and Friday. I'd really like to see something by Friday. You've
no way.
obviously, well,
There's
you've
no way.
obviously been working on it, even if we end up having to do it in piecemeal. So
We've been thinking about it, but we have not, I don't know what you mean by working on it. Yes, obviously, we're working that direction, but Your Honor, there's no way for us to reasonably get that done by Friday. That's just, there's so many other things that we're dealing with, including hearings like this that keep coming up over and over and over.
Yeah, that are a
I-
waste of
I'm not-
everyone's time.
The court knows we don't drag our feet. As soon as we get something, we act on it. I just can't promise that we could get it done by Friday. We are working on it. And we're not,
So
there's no strategy for us waiting, I promise you.
be prepared to discuss it next Friday. I will be looking for it very shortly thereafter, and we will have a hearing on it very shortly.
Oh, don't fail me now.
Time to respond.
Here come the sirens.
So we need to come up with a scheduling order, or I've got a scheduling order that we need to discuss. But regarding this motion, what I need to know before I hear the motion on the expert-related expenses is what sort of protocol you all worked out. Maybe it's in the Commonwealth's opposition that I just saw. What sort of protocol was worked out? Who was notified? What the arrangements were? How this all was set into play, and why there was a violation.
I can certainly brief that for the court. We addressed it pretty significantly in our motion. in terms of the conversations that were had, the expectations that we had, the protocol in terms of getting our expert out there for
No,
Arizona.
what the agreement was, right? People don't just show up for the other side's expert. I just need to know what the agreement was for your expert to view this on that date.
Most of this was reduced to email. I think it'd be
Okay, so
probably
put
a little
it-
bit more accurate for me to just go back and file a supplemental brief.
Yeah, so
Probably
I need all that information from such egregious conduct.
Sure, okay.
All right.
I'll submit a, that won't take very long at all.
Because then we'll address this next week.
Okay, that's fine.
All right. If we do not have an evidentiary Daubert hearing, do we need both days? Or does it make sense to schedule everything for Thursday? What's the Commonwealth's position on that?
Absent that, I don't think there are a lot of matters before the court. The motion for clarification should take probably less than 20 minutes.
Okay.
And the motion for fees is a very simple discussion. So I don't think there's any way we'd need 2 days unless there is actually an evidentiary hearing, and then it'll take some time.
Okay. What do you say, Mr. Jackson? You're nodding.
I agree. I think if there's an evidentiary hearing, it's going to take multiple days. If there's not, I think we can pack everything into Thursday.
All right, because I don't want to waste everybody's time. I want us to get this case moving.
Of course.
So you will then file that motion to dismiss the following Monday or Tuesday, and we
No.
need to set it up for a hearing. If you are indeed filing a motion to
I'm sorry.
dismiss.
The motion to dismiss on which Monday or Tuesday?
After we meet next week.
Following week.
Yes. I just want to get a scheduling order going, so I need some of these dates because we're going to need to schedule a hearing on that. I do not anticipate an evidentiary hearing on that, but I expect it will take time.
He wants it, but they want it by the 10th or 11th.
All right, so the Commonwealth will have all of its discovery to you, it expects, by Wednesday, the 5th.
That's correct.
Okay. We'll be back here at the end of next week. After you have that discovery, I can give you until February 11th, the following Tuesday, to file a motion to dismiss.
Yeah, fastest way to keep this trial moving is to dismiss it, Bev, says
And
Sebastian
Commonwealth,
Anon.
I'll
Thanks,
give
Mr.
you
Chat.
until the 14th to file an opposition to the motion to dismiss.
Only 3 days.
And let's hear it the following week. We're also going to have to, does the defense anticipate any evidentiary motions?
Yes, but I can't tell you exactly what those are, but in an abundance of caution, given the fact that we're expecting new information from the Commonwealth, I think the court can safely
right.
say yes.
So February 21st, and I'll put this in writing, filing of all evidentiary motions that can be an out of court date unless we choose that day to hear the motion to dismiss. Why don't we figure out what's your availability the week of the 17th? The 20th is actually the best day that week for us.
Can't you take a red eye, Mr. Jackson? Hashtag Hank. Yep, delay.
Your Honor, that is that week of school vacation week. Both Mr. Jackson and I have young children, but one of us, I think, could probably be here on the 18th.
On the 18th?
Right.
Yes, Your Honor.
Okay. Well, all right, so I'd like you to get me, can the Commonwealth get me the opposition by midday on the 14th? So I'll have it to review over the
Happy
weekend.
Valentine's Day.
I know you haven't seen it, so it's hard to figure out how much time you need. Is the Commonwealth available on the 18th?
I'm available anytime.
Okay.
Yeah, because you're on a $75,000
We'll put all
retainer.
our effort into it. If we have a problem, we could let the court know.
Okay.
We'll do our best.
Okay. All right. Okay, so the 14th will be an out-of-court filing date. The 11th, an out-of-court filing date. So the motion to dismiss hearing will be on Tuesday, the 18th.
We're going to have a busy February, my friends.
Filing of all evidentiary motions will be the 21st. And that will be an out-of-court date. We will do the hearing on all evidentiary motions March 4th and or 5th.
Motions and lemonade,
I'd
our
like you to block off
favorites.
both days at this point. And if we don't need them, we'll try and, I don't want everybody coming in for just one motion. I know how much work you all have to do to get ready for trial. There's a lot of work I need to do to get rid of trial, but I'd like you to block off those 2 days because we can't have motions to suppress going on and on past that date. I'm going to need some time to review them and write them. So, all right.
It's ski week. That's right.
Can you all come back in on March 7th? You'll file all motions in limine. We'll have a final trial conference. And then we'll have to set up a date for what I anticipate will be at least a day, maybe two, because it was last time on motions in limine.
Motions and lemonade.
All right, so March 7th will be an in-court date.
March. It's going to be in
And
March.
file all motions in limine. And at that time, I want you to tell me how long you expect your motions in limine to take.
Your Honor, do you want those filed by the 7th? All motions eliminated filed by that hearing date?
Yeah, good.
Yes. And on the 18th, which only gives me 2 weeks to decide them.
Well, you're going to have to speed it up.
Because we're starting the trial on April 1st. Jury Commissioner's Office has been fantastic about it, getting us as many jurors as possible.
You're going to have a rough time
And we'll
finding
talk
ones who
about
don't know about
impanelment,
this case.
Obviously, a little bit later. All right. All right. Anything else we need to discuss today?
Not on behalf of Ms. Reed, thank you.
No, thank you.
Okay. All right. Thank you all.
And you're all set. I was hoping we were just being punked too. Hold on, let's watch the walkout. Wow. Wow, wow. I'm gonna have to go rewind and get some of those dates because there's a lot of dates and there's some conflicting reports about what's in court, what's out of court. You are muted.
Goodbye.
The loadout, Jackson Brown. Yeah, thank you. I was going to ask, how long does it take 8 gigabytes to download? He says it takes a really long time. Maybe they have really old Wi-Fi or dial-up. I'm eavesdropping. Hold on.
Muhammad Ali about the George Chuvalo fight. He's a great fighter from Canada.
Muhammad Ali?
Yeah, I saw this and I can't delay it. Read it and show them.
There's hot mics, you guys. You better. Wow. The SJC does need to hurry up with their decision. Something about a fighter from Canada. Yeah. Hang on, because we have 4 new filings to go over, so don't go anywhere yet. Hold on. And that's it. That's where it ends. Wow.
Hey, Rich, pleasure to meet you.
Who's Rich? Hey, Rich, pleasure to meet you. Wow. Come on. I think it's the Wi-Fi in the courthouse. The Wi-Fi in the courthouse. That's how bad it is. Wow. Just wow. All right, let's go to the chat for a second before we start going over all of these new filings. I put a lot of these up before, but so I'm just going to thank you guys. Cast Me Out 420, thanks for gifting 5 memberships. Welcome to all the new bees, the new cupcakes. Amanda, thank you for your super chat. Karen Heatley, thank you for your super chat and for tuning in from Ireland. Melissa, thank you so much for tuning in from Australia. I'm glad you didn't miss the start either. Good citizen, if there are notes that say Karen said she was guilty or alluded to, wouldn't that hold Voss as an accomplice? No. If she had any note, if Voss had any notes that implicated Karen Reed in any way, shape, or form, you can bet your ass that she would have turned him over, that she would have actually reported on it. And remember, that's what Karen said to a reporter one day when she was walking out of court. She said, don't you think that if any of you had any notes that implicated me, that you would have reported about it? And that would have been your giant scoop, or otherwise that would be malpractice on all of your parts. Remember that? I do. Chip Jones, thanks for the 10. Says Brennan isn't on the defense. He's mining evidence and strategy for his real client, Michael Morrissey, when he's indicted. Great point. Olivia chimed in. Melanie, what's funny is Bev didn't order the production of all notes with witness statements from Lally's group meeting with witnesses to collude for their federal grand jury testimony. Great point. Potentially criminal. Thank you for the 5. This was in relation to the attorney for Gretchen Voss. You'd think her attorney would make a bigger stink. That was pretty mild. That has the ripple effects of that ruling are going to be enormous, enormous for every journalist in Massachusetts. If you're a journalist in Massachusetts, I suggest you move because you are not protected. Your sources are not protected. Your source material is not protected. And nobody will ever speak to you again because you can never really be off the record. In Massachusetts, it just doesn't exist. Ghost of John O'Keefe, thank you so very much. I put this up earlier for your $50 super chat. I can't imagine how frustrating it must be for Karen to sit there and watch Bev destroy her life. Just when you think you can't dislike her more, she piles it on. Thank you. Thank you, Kyle, for this super chat that I put up earlier. And Sage for your super chat. Yeah, WTF is right. What the duck? Greg with a rhetorical question. Do all lawyers look this stupid when they have a case this week? No, not all. No, not all, actually. It's not rhetorical. Thank you, Greg, for the 5. Methodology. Thank you for that purple hedgehog for tuning in from Canada and for your super chat. Adam, thank you for your super chat. Mrs. Mojo Rise and Jim Morrison's wife is in the house. The only reason we're on the second trial, Bev, is that there was no option box for not guilty. Thank you for that. Charles, thank you for tuning in from South Africa. This court setup is BS. The prosecutor could send facial expressions to Bev. The defense has the right to see the demeanor of the prosecutor. Yes, 100%. I see Dave Matthews was born in South Africa where I live. Yes, he was. Thank you very much for your super chat. Kyle with a $10 super chat. Hanlon's razor. Don't assign malice when incompetence is an inadequate all right, I'm going to start again. Don't assign malice when incompetence is an adequate explanation. It also reads, sufficient incompetence is indistinguishable from malice. I disagree with Betterow. Bev is corrupt. Thank you, Kyle, for your opinion. What the duck? Thank you so very much for your super chat. Brian, thank you for your super chat. Hank wants him to pull his hair out, and he doesn't have any. Kelly, thanks for the 10. This may be a stupid question. Can't the defense ask the FBI to provide a digital expert to give their expert opinion? There actually was an FBI expert who did opine that the 227 search did happen, but I don't think they need him because they have their own. For those of you who are on the cesspool of Twitter, you know that the other side is getting really, really desperate now because what have they done? They have dug up some dirt on Richard Green. That is allegedly in relation to Richard Green. They have found an old police report from 2016 regarding an alleged bar fight that Richard Green may have been in Florida or something to that effect. It's dirty. They all got their talking points and they all blasted it out there on the cesspool of Twitter. I don't even know if it's the same Richard Green, but that's what they're doing. That is what they're doing. So, astroturfing. That is what they're doing. So, that's what happens over there. I'm not on Twitter, but that's what you guys have sent me. Yes, the Vanity Fair also hired an expert, right? And said that Jen Googled it at 227. Yes, that is 100% correct. At least that's what they wrote about in their article. Thanks, Ange, for your super chat. Alessi's pros, thank you for the 10. Kelly Jane, thank you. Thank you for your super chat. My nurse Kel, thank you for your super chat. Talking about gaslighting. Decline, thank you for your super chat. Mitsa Mays, thanks for the 20, says, getting on the road for a 7-hour drive after a difficult visit with my Alzheimer's mom. I'm so sorry. I know how hard that is. Thank you for keeping me company in the car and making me smile with your Bev impressions. It brings me such joy. Keep me company, please. All right, Mitsa May, safe travels. Safe travels. Hope we're still keeping you company. I don't think we'll be here for 7 hours, but you never know. Reed, thank you. We need to sing the Muppets Upside Down World song. I don't know that song, but maybe we need to put it on our playlist. Burning Queen, thanks for becoming a new member. The Orwellian Unperson. Excellent prose from Alessi's last motion. Thank you so very much. If Gretchen Voss truly cares, she'll take the contempt charge and hide her notes. When does jury selection happen for April 1st, Captain Trips? It happens April 1st. When they say start a trial here, they mean that's when jury selection starts. Thank you, Scorpion, for your super chat. And I love David Reese changed his name again. A Gatling gun dystopian approach that also comes from Alessi's prose of his last motion. Did he say the Commonwealth told Hyde to only use Celebrate? Yes, yes. Yes, he did. He absolutely did. Thank you, Warrior, for your super chat. And Mo for your super sticker. Jean Frazier, thank you. Jeannie Frazier, thank you very much. We are up to 75,034 right now. So we did it. We did it. We broke the dam. We've been bumping up on 75,000 for a long time. And there we are. And I have all of you to thank so very much. And then Anton chimed in. Once we get to 75, we aim for 85.7 to beat Vinnie Politan. I'm in a unofficial competition with Vinnie Politan to beat him on subscribers of his own private YouTube channel that he doesn't even know about. He doesn't even know about it. So yeah, if you could hit the subscribe button, it's free. I appreciate you so very much. As always, Sage, thank you for your super chat. Stacy, thanks for the 10 and for saying 75,000K. Yay, we did it. Thank you. Thanks, Charlie Lynn, for gifting a membership. Sandy Golf Cart Lady, thanks for the congrats. And also Canton's disappearing Sallyport videos. Thank you for the congrats. Karma Matters, Justice for John O'Keefe. Thank you for the Canadian super chat. Alessi could not have explained this any better to everyone that there should not be a hearing. How many think that Bev will still have the hearing? I mean, it's wild. There are no legal grounds for a Daubert hearing. And yet the few things that she did say during this hearing made me think she's going to give it to him. I'll let him have it, as she likes to say. I'll let him have it. And that's just wrong. It's just wrong under the law. Jody, thanks to you for your 10, for congratulating me. Also, can someone put a harmonica in Brennan's mouth, please? Kitty Gee, thank you so much for the $75 super chat. Oh, and gave me a $75 super chat for the congrats on the 75K. That's so nice. As a member of the Massachusetts Bar, I am embarrassed by the Commonwealth, DA Morrissey, the judge, and the police officers involved. Ridiculousness at its finest. Jesus, take the entire vehicle. Thank you so very much for your kindness and generosity. And we have built a really amazing community here. And I thank each and every one of you for that, as well as my amazing moderators who make this a great place to be. Thank you, Cheryl, for being an amazing mod and for tuning in from Canada with a super chat and congratulating me. 100K, here we come. Thank you, Cheryl. Rescue Puppy, it is pronounced cash. I'll allow it. Moon Goddess, thanks for your gifting a membership. Rescue Puppy says hash values are made when files are written to a drive. If file is changed, the hash value will change. Thank you. Yes, we still need to wait for the SJC, Amy. And also Tracy, same thing. SJC is going to have to decide, or she's going to have to adjourn the trial. She can't start a trial without a decision on the juror issue and whether or not Karen Reed was actually acquitted on counts 1 and 3. She needs to check with her handlers, says Donnie Wahlberg. Captain Trips has jury duty on March 26th for Norfolk County. Hoped I had a chance. Well, you never know. They might put you over to April 1st. You never know. My nurse Cal, thanks for the 10. Odds, the team police find 0 red items during the day. Right after the body found, almost no snow, using leaf blowers. Post seizure of car, red is found in deep snow later by a drive-by. What are the odds? Oh. Rhetorical question. Right, Cal? Thanks. K-Mick, thanks for the 5. Of course, Bev can't decide from the bench. She needs to check in with Morrissey to see how to steer this sinking ship. Spirit Healing, thanks for the 20. Hanky Panky Spanky at hashtag. Thank you for your super chat. Sebastian Anon, if my guess is right, instead of having third party look through Meatball's phone forensically, Hank picked and chose it himself. I think so too. Oops. Thank you, Kyle, also for your super chat. If the prosecution sees it, doesn't Karen get to see it too? Nope, because it's supposed to go through a taint team. But instead of a taint team, Brennan wanted to do it himself. That's what makes me think that it's Marcy's phone records. Can Bev proceed to trial without a ruling on the counts? No, still got to wait for that appellate decision. Thank you, Lori. As a wise woman sang, when logic and proportion have fallen sloppy dead, feed your head, effing hippie. Yeah, yep. Ain't that the truth? Mrs. Bucket, thank you for your super sticker. On top, thank you. Zoe B gifted 5 memberships. Thank you, Zoe B. So very much. Kyle. Thank you, Kyle, for your super chat. So the Commonwealth can only look at their own boss's phone. Yes. LA Horseshoe Freckle. Thank you very much for that. Glamasu's, the preparation of the case depends on the SJC ruling. Bev wants a schedule and she doesn't seem to have any common sense. Well, she's going to keep them to that tight timeline until if and when she needs to move it. So that's possible. Ms. Mojo Rising, congratulations to your niece on her new baby boy, 8.3 pounds. Congratulations. You need to bring Brother Counsel on a show. He's interesting to listen to. Thank you for your opinion. Very much. Thanks for your opinion. Paisley Chicken, thanks to 5. If judge denies motion to dismiss, can defense file with SJC for a writ of prohibition pending appeal? Due to there being Brady violations, it's going to depend on the contents of that motion. I don't know what the contents of that motion is or will be yet. So let's table that. Put a pin in that question for later. All right. Let's take a look at some of these new filings. Whew, that's a lot. It's a lot to go through, but we're here for it. We're all here, so we might as well stay, right? Let me see if I can get these in order. 467, 465, 464. 565, 466, and 467. All right. And here we go. First thing that we're going to look at is the So we'll do them in order. The Commonwealth's opposition to the motion for expert expenses. Let's take a look and see what they have to say for themselves about why they didn't have, why Colleen Crawford met their expert there and she didn't know he was coming. It's a cold read for me because these just came in hot off the press. This was filed today, 10 a.m. Commonwealth's opposition to defendant Karen Reed's motion to recover expert-related expenses from the Commonwealth. Now comes the Commonwealth in the above captioned matter and opposes the defendant's motion to recover expert expenses from the Commonwealth. The defendant's suggestion that the Commonwealth mislead, it says mislead, but it's supposed to say misled. And it was mind-numbing that Brennan got up there and talked about the misspelling of gray key when his filings are replete with misspelling, grammatical errors, incomplete sentences, misplaced apostrophes, and so many other things. The defendant's suggestion that the Commonwealth mislead or induce the defendant to incur costs to have an out-of-state expert travel to the Canton PD is a distortion of the facts and has no legal merit. The Commonwealth requests the court deny this motion without a hearing. The Commonwealth has provided the defendant with numerous videos from the Canton Police Department throughout the entirety of this case. Oh, yes. Oh, yes. And even some video after the trial of this case in October of 2024. At no time has the defense ever made a formal preservation request. That's a lie. That is a lie because it is my understanding, belief, and I think we even looked at that David Yannetti made a preservation request on the day that she was arraigned on February 2nd of 2022. Okay. And and that was in district court. Okay. So there's that. If anybody's a copy of that, let me know. In November 2024, the defense made an informal discovery request relative to additional Canton Police Department videos. Special Assistant District Attorney Brennan responded on November 25th, 2024, informing the defense that he would inquire of the Canton PD and or keeper of the records to attempt to identify any potential chain of custody of video footage provided and would request any documentation that may exist relative to the chain of custody of video footage. Provided and would request any documentation that may exist relative to the chain of custody of surveillance video. During the week of December 1st, 2024, ADA Brennan spoke by phone with Attorney Jackson and his co-counsel. Attorney Jackson asked if the Commonwealth would consider, allowing a defense expert to access the Canton PD's camera system, NVR. Thought it was DVR, because I thought that they were, I don't know. See defendant motion at page 2. No motion or order had been allowed or even filed relative to this request. Okay, but if the parties agree, you don't need to file a motion or get an order. Many attorneys, most attorneys, agree on things without having to waste the court's time and effort on a motion. Things that are consented to do not require an order or a motion. Welcome to trial law. ADA Brennan agreed to accommodate the defense's informal request. Okay. So the request was allowing a defense expert to access the Canton PD's camera system, and you agreed. During the phone call, Attorney Jackson expressed concerns that the video footage would no longer be stored, and ADA Brennan acknowledged and shared Attorney Jackson's concern given the passage of time. Attorney Jackson requested the Commonwealth refrain from accessing the system prior to the defense expert's examination. ADA Brennan met with Canton Police Chief Rafferty and received permission for the defense to search for video from the Canton Police Department's DVR system relative to the storage of the defendant's vehicle. So Police Chief Rafferty has to give you permission? Okay. Pursuant to Attorney Jackson's request, ADA Brennan directed Chief Rafferty to advise her staff not to disturb the NVR video system prior to the defendant's expert examination. ADA Brennan also invited the defense to tour the entire Canton police station and note all camera locations. ADA Brennan informed the defense that the Commonwealth would have a forensic examiner from the Norfolk County District Attorney's Office, a Massachusetts State Police trooper present. Okay, their forensic examiner is Colleen Crawford. The Commonwealth videotaped the procedure to memorialize the event. Oh. The defense expert visited the Canton Police Department on December 12th, 2024. Oops. It was learned at that time, nearly 3 years after the incident, that the footage on the NVR was overwritten and the system no longer maintained the original surveillance video. Really? Is that when you're telling us that you learned for the first time that that footage was overwritten? I've learned a little something about the Exact Vision system, which is the system that they use. And you have the ability on that system to preserve video for a legal hold so that it will not be overwritten. I covered this earlier, but I'm going to say it again in case you weren't here. Michael Proctor decided within 16 hours of finding Officer John O'Keefe's body that Karen Reed was responsible for killing John O'Keefe with her car. He put in for a tow at about 2-something in the afternoon for a tow truck driver and a police officer from Dighton to meet him at Karen Reed's parents' house to tow that vehicle back to the Canton Sally Port, which, by the way, Canton PD had already been conflicted out of this case because Kevin Albert was a police officer with the Canton PD, and his brother, Brian Albert, who is a Boston police officer, is the lawn on which John O'Keefe's body was found. Canton PD was conflicted out, but they decided they were going to bring that vehicle back to the Canton PD Sally Port, which is a garage, because it was heated, instead of dropping it at one of the other Sally Ports along the way home from Dighton at other MSP barracks. They knew that that vehicle was the alleged murder weapon from that day on, and every single snippet of video from that Canton PD Sally Port while that Lexus was in his possession should have been saved and put on a legal hold and preserved for the time of trial. There is no excuse for this. He's actually saying the first time it was learned at that time, nearly 3 years after the incident, that the footage on the NVR was overwritten and the system no longer maintained the original surveillance footage. I don't know. Moreover, in efforts to identify video footage and chain of custody, ADA Brennan visited the Canton Police Department, viewed camera locations, and had a discussion with retired Sergeant D. Giampietro. Sergeant D. Giampietro served as the officer who originally obtained and produced video from the Canton Police Department. Sergeant D. Giampietro, sometimes it's spelled Pietro, sometimes Pietro, informed ADA Brennan that he routinely would make a copy of footage obtained from the NVR and preserve footage on the department's work server / hard drive, which is separate from the NVR file system. Okay, is it NVR? Is it DVR? You're supposed to preserve it in its original form, not make a copy and preserve it on the hard drive because that may not have the original metadata. Routinely, just to make a copy. Prior to its motion, quote, for costs, ADA Brennan informed defense counsel during a conference call that retired Sergeant DG, I'm just going to call him for now, would routinely save video copied from the NVR onto the department's hard drive. ADA Brennan offered to produce a copy of the stored footage from the Canton PD's hard drive, or alternatively, allow the defense direct access to the hard drive. The defense deferred this offer and has requested further information about the hard drive storage that is forthcoming. The Commonwealth never suggested that nearly 3 years later, on December 12th of 2024, that video footage from January 29th of 2022 would still be stored on the NVR system, nor did the Commonwealth in any way hinder the defense's desire to have a defense expert view the Canton Police Department NVR, because the time had elapsed. Therefore, the defendant's motion should be denied without the necessity of a hearing. XOXO, Hank Brennan. The footage simply no longer exists. This is so not normal. I'm going to put my volume back to normal, so you guys may need to adjust your volume. 3, 2, 1. Okay. Here we go. No, it's not normal. Of course it should still be stored. They use exact vision. It's called EXACQ vision. There is a way to hold things on a legal hold on that exact device as you're supposed to do. And their argument is going to be, they never asked us to preserve it, so guess what? We just didn't. We just didn't. That's going to be argued next week. Let me just see. That's their opposition. And then look at this. He filed an affidavit with it. He's learning. He's learning. This is document 466. Affidavit of Special Prosecutor Hank Brennan in support of Commonwealth's response to defendant Karen Reed's motion to recover expert-related expenses from the Commonwealth. My name is Hank Brennan. Can't you just picture like a big giant sticker on him? Hello, my name is, like he's at a sales conference. Hold on. I have been appointed special prosecutor assigned as lead counsel for the case of Commonwealth versus Karen Reed. I began my appointment in mid-September of 2024. I learned that the Commonwealth sought and obtained a search warrant for the defendant's phone on February 2nd, 2022. Learned that the phone information was provided to the Attorney General's office pursuant to a privileged filtration protocol to ensure that no privileged information was provided or viewed by the Commonwealth. I learned that the Attorney General's office provided reports relative to communications, navigation information, and Google searches. Wait a second, what does this have to do with the motion for expenses? Is this titled wrong? Am I in the upside down again? I'll keep reading, but I don't know if this is the right document. I recently learned that the Attorney General's office did not provide the Commonwealth with the related raw forensic data from the defendant's phone. Oh, wait a second. So now he says that in order to, after consulting with forensic experts, I believe a comprehensive forensic review of raw data within the scope of the search warrant will provide more information than the reports. Oh, wait a second. So now you're saying, oh my God, you want to talk about a shield and a sword? He just argued in open court that Richard Green didn't, those hashtags, as he called them, which we know are hash values, are not important. And now he says they're important. And this has nothing to do with the motion for costs. And he spelled his own name wrong, someone said. Hank Brennan. Where did he spell his own name wrong? Oh, here, look. Look, it's Hank Brennan. It's Hank Brennan. Nobody knows how to proofread over there. Yes, Cuzco. I began my appointment mid-September 2024, meaning I am no longer responsible for all the shenanigans that occurred before that time. Oh, thank you. Thanks, Charlie Lynn. DP Trio. Thank you. Thank you very much. I like to get it right, and I appreciate you with all of my heart. I learned that the defendants been okay. I learned that the defendants, '(S), been in possession of the entirety of data, including the raw data from her cell phone since 2022. For the love of the traveling Mary. Although I do not believe my requests involve communications, thus not subject to the communications protocol, I requested that the Attorney General's office engage in a filtration protocol for files I requested, including navigation information and Google information. This request was an effort to scrupulously protect the defendant's privilege. I informed the defense of my efforts and the defense advised of its objection. I do not believe the defense has any standing to object. However, after receiving the defense objections, I contacted the Attorney General's office and asked them to limit the production to files identified by the Commonwealth's forensic examiner as navigation files. Based on my conversations with the forensic expert and understanding of what a privileged attorney-client communication consists of, I do not expect any communications to be stored in the navigation files. Upon speaking to the Attorney General's office, it is my understanding that they would like to follow the filtration protocol previously set by this court. And this has nothing to do. This has nothing to do with the motion for costs. But I've already read it, so we'll have to figure out what it relates to later, because this is like a guessing game. It's a puzzle. It's a giant puzzle. It's a giant puzzle. We're supposed to be able to put these pieces together. Everything is labeled wrong. Nothing is spelled right, including Hank Brennan's own name. So what are we doing? Upon speaking to the Attorney General's office, it is my understanding that they would like to follow the filtration process previously set by this court, and by agreement of the defendant, the Commonwealth is seeking clarification so that it can efficiently obtain all data it is entitled to pursuant to the search warrant and to review the data prior to trial. XOXO, Hank Brennan, except for this has to do Karen's phone. Karen's phone information was provided to the AG's office for the FBI investigation. The AG's office provided reports relative to communications, navigation information, and Google searches. They want the raw data, which now they feel is important. And they want her navigation data from her phone, like navigation in where she was going, like map information, or navigation of Google searches. I don't understand what they want here. Does anybody have any idea what the duck is going on here? Because it is clearly entitled Affidavit in Support of Commonwealth's Response to Defendant Karen Reed's Motion to Recover Expert-Related Expenses, which has to do with their expert flying from Phoenix to Canton to go to the Canton PD. Yeah, you need to read it backwards to understand. This is like number 9, number 9, number 9, number 9. Maybe if we play it backwards, we'll figure out the conspiracy. Okay, so there's that. Oh, okay. So then they filed another thing, 467. They're a scratch and sniff office. I can see what they did here. I can see what they did. This is what they did because they just scratched and sniffed. They're very good at overwriting, you'll notice. Here's what they did. They took this affidavit, which has a different docket number. This is 467. 467. And this has the same title, affidavit of, because it says Brennan again. And they overwrote this affidavit to do the other affidavit for their other motion. You see? See how good they are at overwriting things? That's what they did. It's like a scratch and sniff. Look, same title as the one we just read with a different docket number. I mean, you can't even, if you tried to make this up, if you were in a Hollywood writer's room and you wrote this script, the studio would say, you know what? It's too unrealistic. Nobody's going to buy it. It's impossible. It's impossible. It's just too unrealistic. Nobody's going to watch this. It's crazy. The audience is going to see right through it. So here's what they meant to attach, or what they meant to title this title, although they probably didn't mean to say Hank Brennan. My name is Hank Brennan. I've been appointed special prosecutor, assigned as lead counsel for the case of Commonwealth versus Karen Reed. I began my appointment in mid-September of 2024. During my initial review of discovery and documents in the custody of the Commonwealth, I learned of a letter written by Canton Police Department Chief Rafferty, dated August 21, 2024, accompanied by a zip drive that contained video footage of multiple areas of the Canton Police Department. Accordingly, I promptly provided those materials to the defense soon after becoming aware of the information. See Notice of Discovery 47. Well, that solves one mystery. We're up to number 56. So Chief Rafferty, now she's got her hands in it too, is turning over a zip drive in August after the trial of new video from Canton PD. Wow. Just wow. It should be pointed out that Chief Helena Rafferty, her credibility may be at issue because she apparently struck a pedestrian in a crosswalk. I don't know when that was. You guys can tell me when that was. And severely injured a man in her police vehicle to the point where he needed multiple surgeries, and then hid it from her constituents. I think it was an internet sleuth that dug it up. Then she had to come clean. Right. New video in August, but it disappeared by December. Yes. Oh, yes. Oh, yes. Oh, yes. Chris Haley says there's no way on planet Earth they have a zip drive. That's from 1990. 1990 called. They want their zip drive and their dial-up back. Remember AOL dial-up? I had phone calls with Attorney Jackson during the first week of December 2024. Attorney Jackson requested an opportunity to have a defense expert access the Canton Police Department NVR for examination. Is it an NVR or a DVR? I need to know. I agreed to seek permission to follow the defense. To allow the defense to access the NVR for examination. I contacted Canton Police Chief Rafferty and obtained permission for Attorney Jackson's request. I informed Attorney Jackson that I would have an MSP officer attend along with Norfolk County District Attorney Office forensic examiner present, Colleen Crawford. I also informed Attorney Jackson that we would videotape the procedure. Can't wait to see that tape. Roll tape. Attorney Jackson expressed concern that the materials may no longer exist on the NVR, given the time that had passed since the event. Yeah, except for you just gave him a zip drive in August with all new video on it. I agreed with him. And I told him continuous scroll, sorry. And I told him that I had no knowledge whether the material still existed or were overwritten given the passage of time. I never represented that any video from the storage of the defendant's vehicle would exist on the NVR system nearly 3 years after the event. Attorney Jackson requested that I refrain from having anyone access the NVR prior to his expert's examination. I agreed and informed Chief Rafferty of his request that no person access the NVR prior to the defense examination. I personally met with Chief Rafferty and requested that no person access the NVR prior to the defense expert examination, and Chief Rafferty agreed. Signed under the pains and penalties of perjury, XOXO. Hank Brennan. Backdoor meetings with Chief Rafferty. Please don't touch the machine. We really don't know if it still exists. Yes, Edward, yes. Wait, some random copies that this sergeant was just copying to his hard drive, not preserved. This is amazeballs, yes. And VR, thank you, G-Pop's wife. Network video recorder typically used on security cameras, but in some places they call it a DVR system. So I don't know. Yes, Mac RN. He was very careful in how that was worded. Yes. Okay. So, all right, we have to give him a little slow clap for realizing and correcting the error of his ways, because he actually attached an affidavit to this motion. He may have spelled his own name wrong, but at least he attached an affidavit, which is protocol. But let me just go back to the actual opposition. Okay, he's asking that it be denied without a hearing. Okay, I was going to say he didn't ask for any relief, but he actually did ask that it be denied. So let's take a look at their new motion that we already read the affidavit to because it was mislabeled. Gray Space says, I'm just wondering, Gray, did you spell Gray right? I'm just wondering how he's twisting the facts to write this carefully worded affidavit. Yes, he was getting on Green's case for misspelling Gray because, Gray Key is a software, so I guess there's a proper way of spelling Gray. So apparently that means that, it must be wrong because he spelled it wrong. And Karen's guilty because she didn't take her shoes off before she went into John O'Keefe's house on the morning of January 29th when Carrie Roberts and Jen McCabe forced her to go back to One Meadows, even though she had just left One Meadows to see if John was there, and she just missed him. She just didn't see him. Dr. Russell is the GOAT. Thanks for tuning in from Norway. Is Judge Bev allowed to demand they file the motion to dismiss by a certain date? Yeah, she's the gatekeeper. She makes the rules and the deadlines. We'll go over those dates before we wrap. Remind me. Double hashtag value. Thanks for the 10. Is everyone still ignoring the elephants in the room? I've heard nothing since the trial on the Ring video showing the light intact. Yes. If you go on the cesspool of Twitter, everyone over there thinks that the video when the officer came to One Meadows, I think it was like around 8 a.m. to do the wellness check on the children. Everyone thinks that video from the dash cam shows that the taillight is broken. I don't see it. To me, it's caked in snow. Who knows what's been manipulated, what hasn't been manipulated on the mean streets of Twitter? I have no idea. But yeah, it's wild. Thank you, Brennan Hashtag, for being a member for 5 months. Curious, is the jury pool in the same county on April 1st? Yes, they have not asked for a change of venue, so it's going to be a Norfolk County jury pool. If you live there, be on alert for a jury notice. Dallas, we set hold to 1 year because of this very thing. Yes. But I would submit to you that if you're a district attorney prosecuting a case, you're going to want to preserve it. Anyway, right? Until trial, until after trial. That's when it should be preserved. But you're saying it doesn't overwrite for a year. Yeah. Well, guess what? In Dallas, you guys are smart. Sebastian, thanks for the 10. Wait, do you think Hank wasn't comfortable with a third party seeing Morrissey's phone because is Morrissey worried that the feds will subpoena or obtain it from the third party if it's his phone? Well, let's take a look at this motion because this motion is about Karen's cell phone. So let's see if we can try and figure out the puzzle of what he was talking about. Thanks, Kim, for your $10 super chat. Litigation holds are indefinite. Thank you very much. We had we had holds for years. Yeah, I agree. Thanks, Kyle. That's the way it should be. You're right. Edward, holy crap. He's saying without a formal request for preservation of evidence that prosecutor and cops can just let it expire or disappear. I'm not a lawyer, but I know that's not how it works. You're right. You're right. They're gaslighting you because they're really good at gaslighting. Mitsume, thanks again for another 20. Rest stop. Why isn't defense arguing conflict for the attorney acting on behalf of the DA's office to be the one going through the DA's phone? Can the SJC watch and read all information on the case for decision or just the argument? No, it's based on the papers and it's based on the argument. And that is the only thing the SJC can consider because those are the only things that were presented to them. They can't go out and do their own research and watch the trial. That's a great question. Why isn't the defense arguing conflict with the attorney? Well, we don't know because I don't even know what phone he's talking about yet. So let's put a pin in that and we'll see what happens at the next hearing. Kyle, bad enough hiding exculpatory evidence, but deleting it? Yes, they did. Or they just copied it and then they put it in another format. But the hash values or metadata wouldn't be there and it would maybe in a different quality. And that Sallyport video had ghosts appearing in and out of it because it was probably a poorer quality and it skipped. Who is the inconsequential new witness? I don't know. I'm waiting. I want to know too. All right. So here's the other motion that Brennan filed this morning at 10 a.m. This is docket number 465. Docket number 465. 465, paging 465. It is the Commonwealth's motion for clarification of privileged filtration protocols pertaining to the defendant's cell phone. Okay. They've had the cell phone in their possession since February 2nd of 2022, as we just learned from his affidavit that was improperly labeled. So let's see what they're looking for now. It's a motion for clarification. Let me get my red pen because I love a red pen. Now comes the Commonwealth and moves for clarification relative to the Commonwealth's lawful access to the defendant's cell phone. The Commonwealth has legal authority pursuant to a February 2nd of 2022 search warrant to examine the contents, including the forensic data within the defendant's cell phone. See Exhibit A. Because of privileged communications contained within the defendant's cell phone, by order of this court and agreement of the defendant, the Digital Evidence Laboratory of the Attorney General's Office was appointed as the forensic examiner to review the defendant's cell phone pursuant to the search warrant and excise any privileged communications. Okay. So here's what apparently had happened. The defendant alleged, and I remember this, that there may be communications between Karen and her attorney on that phone. On or before, I guess. Well, actually, they seized her phone, though. They seized her phone on January 29th when they seized her vehicle. They seized her phone. So they've had the phone in their possession since January 29th. They didn't get a search warrant to search it until February 2nd, which was the day of her arraignment. Because of that privileged information, the court made an order. It may not have been this court. It may have been, where was she first arraigned? Stoughton District Court? Correct me if I'm wrong. It may have been that judge who said that the AG's office had to be like the taint team, right? So it was not the FBI. This was a taint team ordered by the judge. I think it was Stoughton District, right? And I think it was one of the judges that we heard a hearing with lately that did one of Aidan Carney's hearings. If anybody knows, put it in the chat. You guys are real collaborative and you're amazing. At the conclusion of the Attorney General's office's search and confirmation by the defense that all privileged communications had been withheld from the Commonwealth, the Attorney General's office produced a redacted Celebrite extraction report, including text messages and Google searches from the defendant's phone to the Commonwealth. Yes, and remember she was searching for a DUI attorney, and Adam Lally actually got up and argued in a motion in Lemonade before the first persecution that they should be allowed to argue. Oh, thanks, James. Says you right, girl. They should be allowed to argue consciousness of guilt because she was searching for a DUI attorney. Do you remember that? I remember. Pursuant to the search warrant, the Commonwealth intends to obtain the raw data relative to navigation information and Google searches from the defendant's phone for comprehensive forensic review. Well, maybe it's been overwritten. Maybe it just doesn't exist anymore. The Commonwealth has a good faith and reasonable belief that the privileged filtration protocols for attorney-client communications would not apply to navigation or internet Google search histories. Well, we know it does because Lally argued during the first trial that she was Googling for a DUI attorney. Despite the Commonwealth's belief that this information is not under the purview of the communications protocol, out of an abundance of caution, the Commonwealth requested that a forensic examiner from the Attorney General's office produce the raw data of navigation and Google search files that are within the time frame and scope set by the search warrant. Although the Commonwealth contends that they have independent lawful access to these files, the Commonwealth sought for the independent forensic examiner previously appointed by the court to review the files to ensure that no attorney-client communications nor any other privileged communications were inadvertently produced to the Commonwealth. The Commonwealth informed the defense of its intentions, and the defense is objecting to the Commonwealth's request for the raw data within the scope of the February 2, 2022 search warrant. Okay, so they're going to need to file an opposition to this, and then they're going to argue this on a future date. And yes, 100%, her phone data does not show proof that she ran him over. Given the pending April 1st, 2025, you know what this makes me think? They want the navigation data. They're trying to prove, here's what they're trying to prove. They're trying to prove that in the morning of January 29th, she went out and drove by 34 Fairview and saw John O'Keefe's body. And then she went to Gemma Cabe's house because there's like a time lapse from when she spoke to Gemma Cabe on the phone by using the niece's phone because she didn't have Gemma Cabe's number. And then she went to Gemma Cabe's house, and there's like maybe, I don't know how many minutes in between before she arrived at Gemma Cabe's house. They're trying to show that she went to 34 Fairview, saw the body, went to Gemma Cabe's, went to One Meadows, then came back and found the body. And then because she saw the body in the blinding snow and nobody else did, therefore she's guilty, right? That's what they're trying to show. That makes me think that whatever information they got from the telematics system, hear me out, during this chip off that they went to Texas to do, did not give them any navigation data from inside the Lexus to prove that. Does that make sense? Magnolia Gypsy, they deleted navigation data in the MSP's custody. Now they want to blame her for that too. No, they deleted the location data. Remember, the location data was deleted, I think, forget when, but it was at some point when Karen Reed's phone was in their possession, like maybe around April 2022, something such as like that. That leads me to believe, picking up what I'm laying down, The chip off, chip on, chip off, wax on, wax off. We're in the Karate Kid now. Did not give them that information. And so now they're trying to get it from the phone. But here's the thing. Karen Reed did not know where Brian Albert and Nicole Albert lived. That information was housed on John O'Keefe's phone on his Waze app. She didn't know where they lived. She didn't have the address. They want to know where she was driving around before she went to Gemma Cape's house. That's right. Exactly, Stephanie. You know, you're picking up what I'm laying down. Given the pending April 1, 2025 trial date, the Commonwealth is seeking to avoid any unnecessary delay in reviewing evidence and in consequence seeks the court's clarification relative to the privilege filtration protocol. I don't even know that this was Judge Cannone's order to begin with. And why are they just asking for this now? That's why they're asking for it now, because whatever they were hoping to get from the telematics system, they didn't get. And I don't know what they got, if anything, because I don't have any inside information. Maybe it was all destroyed. Maybe nothing was in there. And then in support of this motion is the other affidavit from Hank Brennan that we read earlier that you may need to rewind because it was labeled wrong. And that, I think, that is paper number 466. So if you want to rewind later and go back and read that, then they're looking for the raw forensic data from Karen's phone for the navigation information and Google searches. And funny how they didn't need it for the first trial, but they all of a sudden need it now. Yes, Joe. Humoring that she did drive by, it still doesn't prove she hit him, which is what they're supposed to prove. I know. It's like smoke and mirrors. It is all smoke and mirrors. It's wild. It is absolutely insane. Yes, you're not insane. You're being gaslit. Thank you so much, Fairy Raven Emma, my sweet pea from Ireland, for congratulating me on the 75K with a matcha latte. I appreciate you so much. Oh, 2 matcha lattes. Thank you, Emma. Thank you so much. Thank you, Faye, also for your matcha lattes. I was glad you're on this. Takes methodology to stay on top of things. Oh, yes. Oh, yes. Oh, yes, it does. Thank you also for another matcha latte from All Shop. I appreciate your overviews and opinions. This case is the case that keeps on giving, keeps me away from the angst of politics. Thank you. Thank you. You guys were watching. And we did hit a milestone today. And thank you for your matcha latte. Says, would you, Jackson and Yannetti, please teach voice lessons to these lawyers? Listening to him is excruciating. You have the best law tube, no doubt about it. Oh, and that is very sweet of you. Thank you so very much. Thank you so very, very, very much. And thank you, Kelly. Thank you for your Venmo for the 75K. And Amanda, thank you. Free Karen Reed for your Venmo. Kelly, thank you. That was $75 for 75K. You're very sweet. Thank you so much, Kelly. Sharon, thank you. It says on Venmo, they just arrested a guy shooting an intruder to his home in December. He's using stand your ground. He's in county jail in DeKalb County, Alabama, AL. Second one in the last few years this happened. Scottsboro, Netflix stock. Okay, thank you. Thank you, Sharon, very much for your Venmo and for that info. I'll take a look into that later. Oh, Stephanie, thank you so very much for the $75 for the 75K. You guys are so kind and generous. And really, this is really the best community, I think, on YouTube that we created here. Thanks to you guys and the moderators. And thank you, Sherilyn, so much for your Cash App, for the congrats. You are so very kind and generous. I think I got everyone. Lisa says, appreciate you. You do such a good job explaining to all of us. You're awesome. She's Goldie on YouTube. Thank you, Lisa, for your Venmo. Appreciate you. And Sally, thank you for your Venmo as well. It's unbelievable. And Heather, Free Karen Reed. Heather says free Karen Reed. Thank you. Thank you. Thank you. Thank you. All right, let's go back to the chat for thoughts, comments, questions, concerns. Is there any more filings? Thank you, Justin Green, for thanking me, for being here for you, just like you guys are always here for me. Please make my video shorter. I can't. It's live. We're going live. We got to cover it while we're here. You can come back later and watch the replay. I still love you, Canine Lover. I love you. And when you come back on replay, you can watch it at 2x speed. But there's no sense if we have, 6,500 people here, there's no sense in quitting now and then coming back later. I'm not a cupcake. I can't make everyone happy. I'm not a cupcake. Edward, thank you. Behind this is the affidavit for his motion for clarification. His other motion, someone attached the wrong one. No, they entitled it wrong. So when I get the documents, I get them separately by number. So I don't get them attached to anything. They're numbered, right? He titled it wrong. It was a scratch and sniff. So that's what their problem was. They didn't retitle that affidavit to match the correct motion. Thanks, Edward, for your super chat. And Jamie got 3. Thank you for using your $10 super chat. Super sticker. Isn't the AG's office also the Commonwealth? No, the Attorney General is the United States. Well, it's the U.S. Attorney's Office for the District of Massachusetts. Thank you, David, for your super chat. Sage, I find it crazy there isn't one clear video of the taillight while the car is running after the ring footage. This also says the car data proved 0. Yes. You know what they do in a proper investigation? They take photos. Because you know what they did in the Penny McGee case, the trial that we're watching, that we're going to reconvene with on Monday? In the Penny McGee case, they took photos of her vehicle. Her Audi was parked outside, and her vehicle had nothing to do with the fact that her ex-husband had a heart attack and died in the foyer. Nothing to do with it. But the MSP took photos. So tell me why there's no photos of Karen's car before the tow. None. 0. Nada. Zip. Just like a zip drive. Thank you, Marianne, for your super sticker. David, didn't Tully testify that her GPS location data was turned off, so they had to use self-tower pings? I don't remember if he testified that it was turned off. I don't remember if you may be right. I may be crazy, but it just may be a lunatic you're looking for. He may have testified that the location data was turned off, but then somewhere else, we learned that it had been deleted while it was in MSP custody. So we'll see. Double hashtag value. The new versions might be taking away that 24 mile per hour speed. Oh, you mean the new versions of the Commonwealth's case? Yes, because maybe whatever they retrieved from the black box data telematic system might belie that fact. Interesting. Hazelnut, I'm wondering if the new witness neurologist has something to divert someone's MS. Do you think the neurologist has to do with Jennifer McCabe's MS? Because Karen has MS. Jennifer McCabe also has MS because she testified to that at the trial, that John wanted us to be friends because we both had MS. And then she also testified during the trial that when she was typing in "hostlong to dying cold," she was shaking and it was cold and she has MS and she misspelled it. So she typed it in twice because Karen asked her to while they were sitting in the backseat of the car, holding hands, praying the Our Father. We've never seen any dash cam footage of that, by the way. I don't know. I thought perhaps the neurologist had something to do with John O'Keefe's massive brain bleeds, which added, and his subarachnoid hemorrhages, which were on both sides of his temple, by the way, and a skull fracture in the back of his head with something like a 2-inch gash and multiple skull fractures. But I don't know. Your guess is as good as mine. Would a neurologist be the proper person to testify to those brain bleeds? Or would you need a neurosurgeon? We circled back to Billy Joel. Yes, we did. Thanks, babe. I know you know. Thoughts? Comments, questions, concerns? Oh, Madeline, thank you. Madeline went back and looked at it. Lally had no objections to that scope. Preserve all evidence. That was the hearing of February 2nd of 2022. Should we watch it? Should we go back and watch it? I can find it. I mean, we're here. Somebody said the video was already too long, but we're only at 4 hours. Sometimes we go for 8 when we're on trial. A neurosurgeon, right? Not a neurologist would be the one to comment on the injuries. Yeah. Let's go back and watch let's do it. I'm going to do it because you know what? We're here for it. Let's go back in time to February 2nd of 2022. I was going to look at Canton Community TV at their channel because they have it. If anybody else has it in a different format that you think is better, fanbase at mlittlelaw.com. A link would be great. Fanbase at mlittlelaw.com. But I think they do have a whole Karen Reed playlist. Give me a sec. All right, let's see. Hearing, okay, the first one here is hearing of May 3rd, 2023. Oh, the neurologist to say he may have survived. Maybe. Yes, maybe. Right, because didn't he make that argument during one of his first appearances? That she's even more liable because if she had stopped after she hit him with her car, his life could have been saved. That's interesting. February of 2022. All right, let's see. Okay. All right, I got it. I found it. Love how we can pivot like this, don't you? I mean, who's better than us? Nobody's better than you guys. That I know for sure. It's only 23 minutes. Here we go. This is Karen Reed's original arraignment from February 2nd of 2022, 2/2/22. Please take a moment to smash the like button while you're here. Thank you so very much. Before we move on to our next activity. All right, here we go. Let me know that you can hear this.
Of a motor vehicle, one count of leaving the scene of personal injury and death. These offenses taking place January 29, 2022 in the town of Canton.
Good morning, ma'am. I'm advising you pursuant to Mass General Laws, Chapter 276, Section 58. Should you be charged with a crime or violate a release condition while this case is pending, you could be held in the House of Correction for up to 90 days without bail. Good morning, Mr. Yannetti. Good morning, Mr. Lally.
Good morning, Ron.
All right. Mr. Lally.
Your Honor, with the court permission, could I just pull the mask?
Yes. Yes.
Thank you, Your Honor. Your Honor, Adam Lally for the Commonwealth. The Commonwealth is requesting that the court set a cash bail in this matter in the amount of $50,000.
with some additional conditions. Those conditions being the bail warnings as just read by Your Honor to the defendant, as well as conditions that she stay away and have no contact with the deceased victim's family, that she stay away and have no contact with the deceased victim's residence, and that she be prohibited from operating a motor vehicle during the pendency of this case. In support of that request, Your Honor, the Commonwealth would cite the nature and circumstances of the offense, as well as the potential penalty that the defendant faces, particularly with reference to the manslaughter charge and the leaving the scene of personal injury and death, the latter being a bind over. The facts of this case, Your Honor, essentially on Friday, this past Friday into Saturday, January 29th, at approximately 6:04 a.m., the Cannone Police Department received a 911 call from a woman reporting a male party subsequently identified as the decedent and victim, Mr. John O'Keefe, who was found in the snow at a residence on Fairview Road.
Did the man passed out in the snow?
At the time of the 911 call, there was heavy snow and the temperature was in the teens. Officers Saraf and Mullaney of the Cannone Police were dispatched to the scene along with Cannone Fire and EMS. Officer Saraf was the first to arrive on scene and observed 3 females waving at him. If you were standing on the roadway looking at the property, the 3 females were in the left corner of that property. Officer Saraf observed the victim lying on the ground as 2 of the females were performing CPR. The 3 females on scene were subsequently identified as the defendant before you, Ms. Karen Reed, Ms. Jennifer McCabe, and Ms. Kerry Roberts. Officer Saraf observed the victim to be cold to the touch, no signs of breath, and returned to his cruiser to retrieve his AED device. At this time, Cannone Fire and EMS arrived on scene and took over first aid. Paramedics then transported the victim to the Good Samaritan Hospital in Brockton, where he was determined to be deceased several hours later. Several detectives from the Cannone Police arrived on scene moments after the 911 call. They began to search within the snowbanks for any evidence, at which point they discovered a broken cocktail-style glass and multiple patches of red substance that appeared to be blood in the vicinity. They secured the glass and 6 blood samples from that area as evidence. Troopers from the Norfolk
In Solo cups. He didn't tell us about the red Solo cups in the Stop and Shop bag because he's not gonna. This is her original arraignment from February 2nd of 2022. We're trying to find out if David Yannetti made a preservation request and what else Lally said during the arraignment. So thanks for asking.
County District Attorney's Office, specifically Sergeant Buchanan and Trooper Proctor, then arrived at the scene, began the process. They also spoke to several witnesses.
Wait a second. He just said Proctor showed up. Hold on a second. He just said Proctor showed up at the scene. Did he not? Listen.
Substance that appeared to be blood in the vicinity. They secured the glass and 6 blood samples from that area as evidence. Troopers from the Norfolk County District Attorney's Office, specifically Sergeant Buchanan and Trooper Proctor, then arrived at the scene, began the process.
Arrived at the scene and began to process. Trooper Buchanan and Trooper Proctor. You heard that, right? Remember District Attorney Marcy's hostage video? Michael Proctor was never at 34th Avenue on January 29th of 2022. But Mr. Lally said this in open court. Let's hear it again. There was also a stay away order. Thanks for pointing that out. She wasn't allowed to go to the funeral. Yeah, they argued the scene meant the police station. Right. They did argue that.
And multiple patches of red substance that appeared to be blood in the vicinity. They secured the glass and 6 blood samples from that area as evidence. Troopers from the Norfolk County District Attorney's Office, specifically Sergeant Buchanan and Trooper Proctor, then arrived at the scene, began the process. They also spoke to several witnesses.
Arrived at the scene and began to process. If Canton PD is the scene that they're saying they referred to, that they responded to, there's nothing to process at the Canton PD. There's no evidence of a crime. You're not processing anything at Canton PD. Every single day they change their story.
Specifically, they spoke to Ms. Jennifer McCabe. She stated that the evening prior, she and some friends were at the Waterfall Bar located within the town of Canton. She stated she and her husband arrived there at approximately 9 p.m. At approximately 11 p.m., the victim and the defendant arrived at the Waterfall Bar together. She indicated to the troopers that the victim and the defendant had been in a dating relationship for the last 2 years, and that the defendant often stayed at the victim's house most nights, is what she described it as. She observed the defendant walk into the bar holding a glass cup from C.F. McCarthy's, which is a bar located across the streets from the Waterfall, with a clear liquid inside and what she believed to be a vodka soda drink. She observed the victim to be wearing.
She never said that. I don't think she ever said she believed it to be a vodka soda. She said there was a clear liquid in it, but I don't know. I'd have to go back and look to her statement. It says, yep, and spoke to several witnesses. Yep.
A baseball hat, jeans, and sneakers. The Waterfall with a clear liquid inside and what she believed to be a vodka soda drink. She observed the victim to be wearing a baseball hat, jeans, and sneakers. The victim and defendants had been at C.F. McCarthy's across the street before coming to the Waterfall Bar, as I stated. She stated that the victim and defendant appeared to be in a good mood, did not observe any arguing amongst the two, described the atmosphere within the bar as friendly amongst the patrons. She indicated as the bar began to close down, everyone was invited back to that residence on Fairview Road. She observed the defendant and the victim leave the Waterfall Bar together. As the group was exiting, the victim texted Ms. McCabe, where to, at 12:14 a.m. She replied with the address on Fairview Road. At 12:18, 4 minutes later, the victim called her to ask where specifically the house was located on Fairview Road. While inside the residence, she observed a black SUV arrive in front of the residence on Fairview Road. She observed this from the front door. She texted the victim at 12:31 a.m., hello, and at 12:40 a.m. texted, pull up behind me. She then observed.
Why is she texting him at 12:40, pull up behind me? Because she's telling him that she still saw him outside at 12:40. She still saw the car outside at 12:40. And we know that Karen reconnected to the Wi-Fi at One Meadows before 12:40. 12:36, something like that.
The black SUV moved from the initial place the vehicle stopped on the street near the driveway and then proceeds to the left side of the property. At 12:45 a.m., she texted the victim hello again and then observed the black SUV drive away.
She observed the black SUV drive away at 12:45. Hello? That's when she observed Karen's car drive away at 12:45. This is the basis for these charges. Jennifer McCabe's statements that Adam Lally is telling you about right now in February of 2022. This is before the charges were upgraded to murder in June of 2022. This is a manslaughter case at this point, but it's based on Jennifer McCabe's statements. And you just heard him say that Jennifer McCabe said she saw the car drive away at 12:45. I'm just going to take it back a second so you can hear that again.
Hello, and at 12:40 a.m. texted, pull up behind me. She then observed the black SUV move from the initial place the vehicle stopped on the street near the driveway and then proceeds to the left side of the property. At 12:45 a.m., she texted the victim hello again and then observed the black SUV drive away. She stated that they discovered the victim in the area where she last observed the SUV on the left side of the property as facing from the street. And at approximately 4:53 a.m., she received a phone call from the defendant looking for the victim. She indicated that the defendant was
4:53 a.m. She gets a call looking for the defendant.
Distraught and drove to her house. She indicated the defendant.
She was distraught and drove to her house. She didn't say John's dead. John's dead. See how the statement kept evolving?
And then indicated to Ms. McCabe that she last remembered seeing the victim at the Waterfall Bar. Ms. McCabe then informed the defendant that she observed the victim and her leave the bar together. Ms. McCabe then drove the defendant's vehicle from her house back to the victim's because the defendant was too hysterical to drive and had the other friend, Ms. Carrie Roberts, follow them. While driving to the victim's house, the defendant stated to Ms. McCabe, could I have hit him? Did I hit him?
Could I have hit him? Did I hit him? Not I hit him, I hit him, I hit him, as Jennifer McCabe testified to on the stand. This is in the car.
Ms. McCabe stated that the defendant told her about a cracked taillight on her vehicle. Once they arrived at the victim's home, the defendant had Ms. McCabe looked at that same cracked taillight.
We saw the ring camera video. No, she did not. Nobody looked at the taillight. That was a lie. Jennifer McCabe did not know that they had or were going to get ring camera footage from One Meadows that shows them arriving there and nobody looking at the taillight.
Ms. McCabe described the passenger side right rear taillight as cracked. They then
Cracked. She says it was cracked. She didn't say it was shattered with pieces missing. This is very interesting because they didn't upgrade the charges until after they did a whole grand jury and Jennifer McCabe and everyone else came in to testify to all different stuff. To upgrade to murder.
both entered Ms. Roberts' vehicle to look for the victim, with the defendant seated in the back as Ms. Roberts drove and Ms. McCabe was seated in the front passenger seat.
Wait, hold on.
The defendant had Ms. McCabe looked at that same cracked taillight. Ms. McCabe described the passenger side right rear taillight as cracked. They then both entered Ms. Roberts' vehicle to look for the victim, with the defendant seated in the back as Ms. Roberts drove and Ms. McCabe was seated in the front passenger seat. Ms. McCabe stated that they turned onto Fairview Road from Chapman Street. At the time, it was snowing heavily, creating poor visibility. Ms. McCabe stated that just prior to the residence on Fairview Road, there was a cluster of trees, and immediately the defendant stated that she saw the victim. Ms. McCabe and Ms. Roberts were not able to see the victim and were initially confused by the defendant's statement. Ms. McCabe stated that Ms. Roberts began wiping snow off of the victim as the defendant laid on top of him for warmth and then began CPR. The troopers then proceeded to the Good Samaritan Hospital to view the victim. They observed approximately 6 bloodied lacerations varying in length on his right arm, the cuts extending from his forearm.
There was a lot more than 6 lacerations to his right arm. Listen, wait, I want to hear this again because this, I don't know that I've watched this recently. Hold on.
Stated that the victim. Ms. McCabe and Ms. Roberts were not able to see the victim and were initially confused by the defendant's statement. Ms. McCabe stated that Ms. Roberts began wiping snow off of the victim as the defendant laid on top of him for warmth and then began CPR. The troopers then proceeded to the Good Samaritan Hospital to view the victim. They observed approximately 6 bloodied lacerations varying in length on his right arm, the cuts extending from his forearm to his bicep. Both of the victim's eyes were swollen shut and black and blue. They observed a cut to the right eyelid area of the victim. Observed his clothing to be blue jeans, an orange t-shirt, a long sleeve shirt, and boxer shorts that were saturated with blood and vomit. They observed 1 black Nike sneaker with a white Nike logo on the sides belonging to the victim. On the 31st, the troopers attended the autopsy of Mr. O'Keefe at the Office of the Chief Medical Examiner. The doctor performed the autopsy. Dr. Scorti below advised of several abrasions to the right forearm, 2 swollen black eyes, a small cut above the right eye, a cut to the left side of his nose, approximately 2-inch laceration to the back.
So he had 2 cuts on his face, one above his eye and one on his nose. But, you know, it didn't look like he was in a fight at all.
Back of his head, multiple skull fractures that resulted in bleeding, and further advised that the victim's pancreas was a dark red color, indicating that hypothermia was a contributing factor to his death. On January 29th, the troopers conducted several other interviews, including Ms. Roberts. During the course of Ms. Roberts' interview, she indicated that she was initially contacted by the defendant, Ms. Reed, at 5 a.m., that she answered the phone to hear the defendant state, "John's dead. Kerry, I wonder if he's dead. It's snowing. He got hit by a plow."
Okay, remember this is 29, 30, 31. 4 days after, 5 days. Remember how many phone calls there were between Jennifer McCabe and Kerry Roberts, and the 2 of them had only met once before, years prior, when John O'Keefe took them shopping for sneakers because he had a discount at Reebok or something? How many phone calls Jennifer McCabe had with Kerry Roberts from January 29th on, and how she testified that Mrs. O'Keefe told them that they should get together and make a timeline. And we've listened to the audio recording of Kerry Roberts calling Canton PD to find out if anybody reported a John Doe or anybody, was a hit and run or anybody had been found wandering around or was in the hospital or anybody got picked up, and spoke to Sergeant Good and said she had spoken to Karen and she was worried because he didn't come home. And, maybe there was an after party. It was a blizzard. And Good made a joke like, oh, I didn't get invited to the after party, the blizzard party. Kerry Roberts never once said during that phone call, she called me hysterical, said, he's dead. He's dead, Kerry. He got hit by a plow. And you can bet your bottom dollar that if Karen said that to Kerry on the phone, Kerry would have said that when she called Canton PD. Wrong or right? Right or wrong? What do you think? Listen, hear that again.
Conducted several other interviews, including Ms. Roberts. During the course of Ms. Roberts' interview, she indicated that she was initially contacted by the defendant, Ms. Reed, at 5 a.m., that she answered the phone to hear the defendant state, John's dead. Kerry, I wonder if he's dead. It's snowing. He got hit by a plow. The troopers also on the 29th proceeded to the defendant's parents' home in Dayton, Massachusetts, where they located the involved vehicle, which is a 2021 black Lexus SUV. That vehicle was ultimately seized and taken back to the Canton Police Department, where it was processed by various factions of the state police. Their observations of that black SUV indicated a crack in the right rear taillight.
A crack in the right rear taillight. The observations of Proctor and Buchanan when they got to Dayton, a crack in the right rear taillight. A crack. I'm going to say it a little louder for those in the back. Adam Lally, as an officer of the court, as an assistant district attorney in the Norfolk County DA's office, is reporting during this initial arraignment, officers reported seeing a crack in the right rear taillight. Let's listen to that again. Funny how that story evolved.
This is a 2021 black Lexus SUV. That vehicle was ultimately seized and taken back to the Canton Police Department, where it was processed by various factions of the state police. Their observations of that black SUV indicated a crack in the right rear taillight. They did speak with the defendant. She indicated that she had met with the victim at the C.F. McCarthy's bar in Canton at approximately 9 p.m. on the 29th, that he was there with several friends prior to arrival. She stated the victim was consuming beer and she was drinking vodka sodas. She described the glassware she was drinking out of as a vase style. She stated she and the victim left C.F. McCarthy's and went to the waterfall. That she did not, she indicated to the troopers that she did not leave C.F. McCarthy's or enter the waterfall bar with a glass of drink. She stated that she and the victim were at the waterfall for approximately 1 hour. During that time, there were no altercations and no injuries, no cuts or abrasions that occurred with the victim. She indicated that
It's because the dog hadn't attacked him yet.
They left the waterfall and were invited to the house on Fairview Road. She stated that she dropped the victim at the house on Fairview and went home since she was having stomach issues at the previous bar. She stated
She has stomach issues. Not only does she have Crohn's, but she had most of her colon removed. Something like 9 surgeries during the course of a very short period of time when she was, I think, in her 20s. Don't quote me on that, but something such as like that. I hear people are screaming on the cesspool of Twitter that if she had to go to the bathroom and she had stomach issues, why wouldn't she just go into 34 Fairview and go to the bathroom there? If anybody knows anybody with Crohn's, if you know the answer to that.
that she dropped the victim off. She made a 3-point turn in the street and left.
He's saying that she said she made 10 surgeries in 2 years. Thanks, Ann.
That she dropped the victim at the house on Fairview and went home since she was having stomach issues at the previous bar. She stated that she dropped the victim off. She made a 3-point turn in the street and left. Did not see the victim enter the house. She indicated that she first observed the broken taillight in the morning and did not know how she broke it the previous evening. She indicated that she discovered the victim in the morning. She observed him lying face up, snow on his legs, eyes swollen, and blood coming from his nose and mouth, and that she provided mouth-to-mouth upon her arrival. Further indicated that throughout the night she'd been calling and texting the victim numerous times with no response. Officers also interviewed several first responders, including a firefighter paramedic from the town of Canton, indicated that she arrived on scene, observed the victim's condition, went to speak to the defendant in regard
Katie McLaughlin, that's Katie McLaughlin, who went to high school with a girl named Caitlin Albert.
to any sort of prior medical issues or causality of the injuries that she observed to his face, to which the defendant then made several statements to her indicating, I hit him, I hit him, I hit him, I hit him.
Oh, 4 times. Okay, but the question that Katie McLaughlin asked Karen was, do you know how he got these injuries to his face? And she said, I hit him, allegedly, which I would have thought meant I hit him in the face, smacked him, slapped him. I don't know. Didn't say car. I hit him with my car. Her car wasn't even there. Oh,
As I mentioned, the black Lexus SUV was seized. There were fragments of broken glass that were observed on the rear bump of the vehicle. The rear right passenger side taillight was shattered, pieces missing.
Oh, now it's shattered with pieces missing. Remember, this is February 2nd. This is after the search team went back after, like, it was unattended. The scene at 34 February was unattended for, I don't know, 10 hours. Now it's shattered, but everyone else said crack. Anybody notice the slight difference there?
From the red and clear areas. On the right side of the rear tailgate, a deep scratch and minor dent was observed. On the right side of the rear bumper, above a small red light, 2 scratches were observed in one area where paint was chipped off. Troopers from the Collision Analysis and Reconstruction section of the State Police performed several tests on the vehicle, including a rapid acceleration forward and reverse, noting that there was no deficiencies with the braking system.
They did a rapid acceleration, forward and reverse testing at the Sally Port. Could that have been when the car got up to 24 miles an hour in reverse? He just said they did a rapid acceleration, forward and reverse test. Listen, reasonable doubt? Maybe.
Was observed on the right side of the rear bumper above a small red light. 2 scratches were observed in one area where paint was chipped off. Troopers from the Collision Analysis and Reconstruction section of the State Police performed several tests on the vehicle, including a rapid acceleration forward and reverse, noting that there was no deficiencies with the braking system. They also implemented the use of a training figure resembling a human approximately 6 feet in height that was placed behind this Lexus. It was operated by members of the CARS unit and documented with video. The vehicle was placed in reverse and started to travel towards said training figure. The rear view camera on the vehicle was operating properly, providing a 180-degree visual. And as the Lexus traveled closer to the figure, both auditory and visual cues began to sound off within the vehicle, indicating an obstruction to the rear. In addition, on the 29th, the Massachusetts Special Emergency Response Team, or CERT, was activated to assist in searching for potential evidence outside of the residence. Standing on the street, looking to the left of the property, there was a fire.
Okay, hang on. The CERT team showed up, but what we learned from the watching the Penny McGee trial is that crime scene services are supposed to come. That's who collects evidence, not the CERT team.
Began to sound off within the vehicle, indicating an obstruction to the rear. In addition, on the 29th, the Massachusetts Special Emergency Response Team, or CERT, was activated to assist in searching for potential evidence outside of the residence. Standing on the street, looking to the left of the property, there was a fire hydrant located there. In that area, they located a black Nike sneaker with the white Nike logo along the side, matching that found on the victim's body. In the area of the street where the victim was recovered. In addition, in that same area, they located 2 red plastic pieces of a taillight consistent with the missing pieces from Miss Reed's black Lexus SUV, as well as 1 piece of clear plastic piece of a taillight located in the same area, also consistent with the broken taillight on the Lexus SUV. Your Honor, with The nature and circumstances of those facts, as well as the potential penalty the defendant faces on these charges, the Commonwealth is requesting that the court set a $50,000 cash bail with the conditions as outlined previously.
Thank you, Mr. Lally.
Thank you.
Mr. Yannetti, and if you would, go right to the mic.
Thank you, Your Honor. Good morning again, Your Honor. David Yannetti for Karen Reed. Judge, my client is 41 years old with no criminal record. My client grew up in Taunton, Massachusetts. She's a graduate of Coyle Cassidy High School in 1998. And when it came time to go to college, she stayed in Massachusetts and went to Bentley College. She graduated with a Bachelor of Science in Finance in 2003. And since then has worked in the financial sector. And in fact, she's been at a very large, well-known financial company since 2007, where she's currently an equity analyst. In addition, she's an adjunct professor at a Massachusetts university as well, and she's been there since 2008. In addition, Judge, my client suffers from a host of medical issues. From the time that she was 25, she's had multiple serious illnesses diagnosed, beginning in 2005 with colitis, which ultimately led to her colon being completely removed in 2009. She's been in pain for a number of years, and eventually also was diagnosed with MS as well in 2013. Continued to have digestion issues and bowel issues. And this past summer, my client unfortunately was diagnosed with having a brain tumor as a result of migraines that she had never had before. There is still no answer regarding whether that.
People are accusing him of lying about this brain tumor. I don't know whatever happened with the brain tumor, but he's an officer of the court. Why would he lie in open court about her brain tumor?
Brain tumor is cancerous or not. And I bring this up not for the purpose of evoking any sympathy, but to focus on what the court's inquiry is here today. The inquiry is, what is the likelihood that my client will appear in court for her trial? Does bail need to be set to assure her appearance at trial? And if so, how much bail should be set? Her roots are here. She was born here, she went to school here, she went to college here, and her doctors are here. And in addition, her family is here. Her parents are present in the courtroom, her brother and her sister-in-law are present in the courtroom. And Your Honor, just so the court's aware, I'd like to have a letter that I sent to the Norfolk County District Attorney's Office this weekend. It was faxed on Saturday, where I promised that my client would appear if they just called me. All they had to do was notify me, and I wrote right in the letter that she would report to any police barracks or police station or courthouse to which they directed me. They ignored that and instead got an arrest warrant for my client. However, she knew. She had hired an attorney since January 30th, this Saturday, because the police had come and they had taken her phone and they had taken her car. She knew that they were considering her a suspect, rightly or wrongly. And what did she do? They arrested her at the very address that I included in my letter to the Commonwealth, which the Commonwealth ignored. This is relevant, I would assert, Judge, regarding whether she is a flight risk. I think that it doesn't really pass the straight face test. She is not going anywhere. She didn't go anywhere. I frankly don't think they've overcome the presumption of personal recognizance in this case. With regard to the facts of the case, Judge, I've read the affidavit that the prosecution has now read. Manslaughter is a tremendous reach in this case. I don't see any criminal intent that would justify manslaughter in that affidavit. And there's a reason for that, because there was no criminal intent. This was not some random stranger. This was my client's boyfriend, somebody with whom she was in love, somebody with whom she essentially lived with. And by the way, the police have her phone. At 4:30 in the morning, my client is placing multiple calls to the victim in this case, to her boyfriend. wondering where he is, why he hasn't come home, and getting annoyed with him because his niece, of whom he was a guardian, had to go to bed without saying goodnight to him. She had no idea that he was deceased or that anything had happened. At 5:30 in the morning, she's placing probably about 10 calls to him for the same reason before she now knows something's has to be wrong, because he never stayed out at night without her. If they were ever out at night, they were always together. He had never not come home. And that's when she calls her girlfriend and goes back to the scene and sees this horrific scene. So, Your Honor, this is a defensible case. There is no reason for her to run. She's done the opposite. She hired an attorney almost right away. And by the way, there will be substantial issues regarding a motion to suppress statements here. As I put in the letter, and I'd like to, again, have this marked as an exhibit for the bail hearing. As I put in the letter, the police multiple times violated her.
Mr. Lally, any objection to the letter committee?
No objection.
All right, thank you. We'll accept it. We'll mark it.
Thank you very much.
Go ahead.
Yeah, the police violated her right to counsel multiple times, Your Honor, and we'll be able to show that at a motion to suppress hearing. Their case essentially comes down to statements, because there's no eyewitnesses. There doesn't appear as though there's any video evidence. There's nothing to indicate what actually happened.
Well, they did claim, they did tell the press there was Ring video camera footage of her hitting him with the car
On the day in question. And I think the police sort of acting out of desperation, realizing that they didn't really have much of a case, needed some type of confession from her. She did not give it to them, and yet they questioned her despite the fact that she asked for a lawyer. So the bottom line, Judge, is it's a defensible case. She's not a flight risk, and recognizing the seriousness of the charges, I won't ask for personal recognizance, but I would assert to the court, this case does not justify more than a $5,000 cash bail.
Thank you. My guess is you have no objection to the proposed conditions.
Well, the only condition that I would ask to be heard on, Your Honor, is this condition that she not drive. The police and the district attorney's office and the registry of motor vehicles have options to address that issue if they believe that she's an unsafe driver. And I would ask the court not to get involved with that issue.
Thank you. All right, with regard to the conditions, she is ordered not to drive unless licensed or permitted by the Massachusetts Registry of Motor Vehicles. I appreciate your argument, Mr. Yannetti, but due to the nature and the circumstances of the offenses charged, specifically 1 and 3, and the potential penalty, I know what your letter says, you're the lawyer, but she has plenty of reason to flee. Given the potential penalty, I'm opposing the $50,000 cash.
There's a motion filed by the district
Yes, on the motion, I have Mr. Lally, a motion for preservation of evidence. Have you had a chance to review it?
I have, yes, Your Honor.
There it is. That's what we were waiting for. A motion for preservation of evidence was made on February 2nd of 2022. And now Brennan is coming in saying they never made a motion to preserve any evidence. Hello. There we go. I told you this was going to be worth watching. Cats Meow 420. My girl, I told you. There's no motor vehicle accident report. Let's play this a little bit louder for those in the back.
Letter says you're the lawyer, but she has plenty of reason to flee. Given the potential penalty, I'm opposing the $50,000 cash.
There's a motion filed by the district
Yes, on the motion, I have Mr. Lally, a motion for preservation of evidence. Have you had a chance to review it?
I have, yes, Your Honor.
Do we have any objection to it?
I do not, Your Honor.
All right, thank you. I'll allow that.
Never did.
I'll allow it. Motion for preservation of the evidence. Do you object, Mr. Lally? No, I'll allow it. That is it. That is all that you need. 3 days. 4 days. What is it? 30 days, September 30, 31, 1, 2. 4 days later, he made a motion for preservation of the evidence. Mr. Yannetti made it. Was not objected to by Lally. This is Judge O'Malley, right? Judge Daniel O'Malley granted it. So guess what, Brennan? Maybe maybe you should have gotten a little more up to speed on this case. Okay? Okay? Because there it is. You could link this video. This is on Facebook. This is Channel 5 WCVB. I'll allow it one more time.
Mr. Lally, motion for preservation of evidence. Have you had a chance to review it?
I have, yes, ma'am.
Do you have any objection to it?
I do not, Your Honor.
All right, thank you. I'll allow that.
I'll allow
Exhibit
that.
D, please.
And just to be clear for the record, with regard to that motion being allowed, Judge, I would ask that it be effective with the court's signature with regard to previous reports that have been filed and anything that's been gathered, and certainly going forward. There should be no destruction of notes going forward in this investigation.
There you
Well,
go.
it speaks for itself.
Yes.
It's a preservation of evidence. I just signed it. It's 10:22 a.m. on February 2nd. That's when it's effective.
Thank you very much, Ron. In terms of the next date, could I have March 1st, Judge?
Oop, there it is. Oop, there it is. In perpetuity. In perpetuity, of course he remembers that. Of course he remembers that. Of course Mr. Yannetti remembers that. You think, right? Of course he does. He knows what he's doing. This ain't no 2-bit amateur operation. This ain't his first rodeo. Exactly. I just wanted to prove it to myself. Thank you, Letteros by Betterow.
Sure. Mr. Lally, that work for you? If not, we'll go to another day.
If possible, yeah. If possible, the 3rd or the 4th, if that's.
Well, I mean, she is entitled to be brought back within 30 days.
Sure.
I mean,
But
I could do-
Mr. Lally, if I may, Mr. Lally, you can have a 9 o'clock, 11 o'clock, or 2 o'clock call.
and thank you. 11 o'clock on the 1st is fine.
All right. That work, Mr.
That
Yannetti?
works.
Thank you.
Mr. Docket 22 CR 66, court is setting bail in the amount of $50,000 cash to ensure your presence back here March 1st for a probable cause hearing. You have a right to petition the Superior Court for a review of that bail. Conditions of this case are that you stay away and have no contact with the victim's family, stay away from the victim's residence, and do not drive a motor vehicle unless permitted to by the Registry of Motor Vehicles. You'll need to have
She was not allowed to have any contact with the victim's family. And remember when Erin O'Keefe got up and testified, Paul's wife, she was very upset that she never heard from Karen again. She was ordered not to have any communication with them or any contact. She couldn't go to the funeral. And she had to stay away from One Meadows too.
sign those conditions before you're transported today.
Thank you, Ron.
Thank you.
Thank you, Ron. Thank you, man.
Okay.
All right.
There you go.
Court stands in recess. Gonna ask you.
2/2 of 22, when everyone was still wearing masks. Yeah, such a weird thing to lie about. Shows how creative and diabolical they are. Very shock and horror. What else do we recognize in the courtroom? Well, there's the friend that was there today. He's right here in front of the court officer. Middle row.
He's not ready, asking for an update.
Wow. Wow. So if you ever had any doubt that you're being gaslit, there it is. No reason to doubt. Could we have Judge O'Malley? That would be great if we could have Judge O'Malley. Thank you, Michelle, for your compliments. 7 months. 7 months. Thank you. I appreciate you. She says I'm the only one she watches on YouTube. Hubert, thank you for the 5. Severe injuries to the back of the head could damage the brainstem, which controls breathing and respiration. They probably knew it was too late to save. Yeah, and also that would cause you to vomit. Right? Thank you, Mama She, for the $75 for 75K. I love you with all of my heart. I love you with all of my heart. Very, very generous and sweet of you. Free Karen Reed, Fab 4 for the win. Thanks for the 10. David Yannetti asked the judge at the very beginning of this case to preserve all the evidence pertaining to the case. I think I'm a little bit behind. You may be. Thank you for your 10. We just played it. We have the receipts. We come with receipts. We have them. And wow, just wow. Thank you. Young Black economist. Karen needs donations. All her savings have gone to this case. She worked 2 jobs to make ends meet, and parents have refinanced her house Next would be them going homeless. Donate $5 if you can. Please, if one of the mods can put in the chat the link to the Karen Reed GoFundMe. It's not GoFundMe, it's like Give, Send, Go. If you don't have that, I will find it. But also there is a giveaway. It's $50 a ticket, and the giveaway involves dinner with Karen and Alan Jackson. If you would like those details, I will find them for you in a second, as soon as I can. Thank you for reminding, Young Black Economist. I appreciate you. Ghost of John O'Keefe coming in with a hot 50. Again, you're very, very generous to this channel, Ghost of John O'Keefe, and I appreciate you more than you know. What happens if they can't seat a jury in Norfolk County? So far, there's been no motion for a change of venue. They will have to keep impaneling people until they can find 12 jurors and a couple of alternates that are impartial. I think they'll be able to. They're just going to have to keep calling in jurors until they do. But that's a great question. I don't know if they can get it. I don't know if she can get a fair trial in Norfolk County, because people who live in Canton and in Norfolk County have to live there. And many of them are anonymous. Many of them have emailed me and said, I would love to tell you something, but I need to be anonymous. And, for whatever reason, they have to live in town with the Alberts and the McCabe's, and they may not want to serve on a jury. So there's that, it could be a thing, like a real thing. People have fear. They have to live in that town. Just pull up something for you guys. 1 second. I'm just a girl in the world. Thanks to 5. Why didn't Jen McCabe send a follow-up text asking John O'Keefe where he went if he never came in the house? That's a great point, because she kept calling him and calling him and calling him all night. I think there were, I don't remember how many calls. You guys can remind me, maybe 15, 16 calls to him that were all deleted in her phone. And that was found also in the extraction. But she did keep calling him. We know that. We know that. Here's the information if you would like to enter the giveaway. There will be 2 winners. Enjoy dinner with Alan Jackson and Karen Reed on February 7th, 2025 at 7 p.m. Details on location will only be provided to the winners. Each winner will be able to bring a guest with them. Please make a $50 donation, unlimited entries. All donations will be made directly to Karen Reed. Below are the following ways to make the donations: freekarenreed.net. There's a Venmo for Karen, a PayPal for Karen, and it says rules. Once the donation is made, you need to screenshot your donation and send it to me in a message. The giveaway will start on 1/19 and end on February 2nd, and the wheel will be spun. I think this is from the Justice for John O'Keefe webpage. Facebook group. So you have until February 2nd, and then they're going to spin the wheel. And there's that. If you guys are interested, I'm sure many of you would like to have dinner with Alan Jackson and Karen Reed. And I know that she appreciates every bit of support that she can get. Freekarenreed.net. Let me just look that up and I'll put the link in the chat. Hold on. When we were talking about Ashley Benefield the other day, and I had a conversation with Neil Taylor, they set up a defense fund for Ashley's appeal. Her appeal is going to cost $100,000. So you can imagine, my friends, how expensive this is. She's already $5 million in debt. Let me put this link in here. I will pin it. Oh, I will also link it in the video description or the show notes below if you're watching on replay. It's pinned in the chat. Thank you, Young Black Economist, for reminding us Thank you. Goes to John O'Keefe. We just addressed that. I'm just a girl in the world. Tammy Tebow, thanks for the 5. Funny how JM says man in the snow, but then he's her friend that she loves. Yes. Tammy Tebow, let me know if you're involved with a summer camp. If you know, you know. Kyle, thanks for the 5. I wish I could tell Karen Reed about celiac something. Jen can suffer for all I can. It's a previous record shows the obfuscation. I don't know. What do you mean? Medical records? I don't know, Kyle. Thanks for the 5, though. Edward, I didn't think Trooper Paul's tests were before this hearing. How can he be talking about all of this? Who performed these tests? I don't know if it was Trooper Paul who did this at the Sally Port. But remember, they seized that car on the 29th. And this was in the evening or around a time that they lied about. It was around 4:15 that they seized it. I don't know when they did the test, but it was before February 2nd, apparently. Thanks, Edward, for bringing that up. Charlie Lynn, thanks for your 5. They should not need to file a motion to preserve the evidence. No, you shouldn't need to, but he actually did. He did. And it was for all previous evidence and all evidence going forward until this case is over. Yep. The motion to dismiss is going to be straight fire. I agree, Edward. Proof that even short, because thank you, Kyle. I don't want to defame anybody on my stream. Don't get me in trouble. Oh, James says, if I won, I'd give it to Olivia Lambo. Thank you for saying that, because she did send me a Twitter post that she made. So let's take a look at that. She was so outraged during this hearing. She was texting me, and here. Let's check it out, because Olivia is fire. If you choose to, engage on the cesspool of Twitter, please follow Olivia at Olivia Lambo. She's been on my show a couple of times. She has amazing insight. She's wicked smart, and she's able to connect a lot of these forensic dots for us, or for me anyway, that it's not my forte, let's just say. And so she is able to do that for us, and she's an amazing resource. So hang on, let me enlarge this so we can put it up on the screen. Here we go. Breaking. The Commonwealth, after paying an employee of Celebrite, a law enforcement-centric tool, to change a feature in an update to one of its programs to comport with their narrative that Jen McCabe's incriminating 2:27 a.m. Google search didn't happen, subsequently limited its request of its expert, Jessica Hyde, to have her conduct her new analysis using only this forensic tool, Celebrite. Interestingly, the Commonwealth's own experts, Ian Whiffen and Jessica Hyde, are both well aware of the necessity and importance of the DFIR industry standard of examining data using multiple different digital forensic tools for the sake of redundancy, accuracy, and comprehensiveness. Jessica Hyde testified to this at the first trial, and both have stated as such countless times across their respective careers in the DFIR space. This is supported by the fact that Jessica Hyde, in her initial analysis for the Commonwealth, did just that, used multiple different forensic tools. Shockingly, the Commonwealth has now asked its expert, Jessica Hyde, to abandon the very industry standard of using multiple digital forensic tools to analyze the data extraction of Jen McCabe's cell phone, to now using only one tool, the same tool and its specific update, Celebrite Physical Analyzer Insights, which was changed without explanation by the Commonwealth's own expert, Ian Whiffen, only after they hired him and paid him for this case. As can be seen in Jessica Hyde's original analysis and report, she employed the industry standard methodology of using multiple digital forensic tools. Attached. Specifically, Hyde's report states that beyond using Celebrite Physical Analyzer, version 7.6.10.12, the image was additionally processed with the following tools: Axiom version 7, iLeap version 1.18.6, Artex Beta 2.6.10. Additional analysis of SQLite databases was performed using Sanderson Forensics Browser for SQLite version 3.3. Inexplicably, in Hyde's new analysis and report for the Commonwealth, she's now abandoned this industry standard methodology to obey the Commonwealth's direction and only use the digital forensic tool that gives the answer they want. An answer which was only effectuated after the Commonwealth paid the very person at that company to effectuate it. Beyond that, however, Hyde notes in her new report that she also conducted a manual analysis, and it was in that analysis that she still found the 2:27 a.m. timestamp, confirming Jennifer McCabe's incriminating Google search, thus still being unable to rule this artifact out. Also of note, Ian Whiffen notably did not use several digital forensic tools in conducting his analysis. In fact, Whiffen only used two tools, Cellebrite and his own tool, Artex, both of which he has either direct control over or the ability to directly control the contents of which they report. Seems like a conflict of interest, don't you think? A Daubert-Lanigan challenge is premised in challenging an issue and an expert's qualifications based on the reliability of the methodologies they use. Richard Green, the defense expert, used several digital forensic tools to conduct his analysis, including the tools used by both Hyde and Whiffen and more. And all of them confirmed Jen McCabe's 2:27 a.m. Google search. Specifically, Green states, quote, the data images have been processed and reviewed with Cellebrite Physical Analyzer, V761012, and Axiom Forensics, V611. Additional forensic tools utilized include Belkasoft X, Sanderson SQLite Forensic Explorer, and CellHawk by Hawk Analytics. Additionally, at the first trial, Green testified to using even more tools, including Whiffen's Artex. So, if there is a question about the admissibility of expert testimony based on a Daubert-Lanigan challenge, the only experts who that is appropriately applied to are the Commonwealth experts, both of which have abandoned and not employed the industry standard, reliable methodologies in conducting digital forensic analysis. That is Olivia Lambo's mic drop of the day with some attached video. And she's already got 10,000 views on that. And that was from 11:47 this morning. So if you're on the cesspool of Twitter, follow Olivia Lambo for all kinds of breaking news and explanations for things that are too complex for me to break down for you. Lisa Mal, this trial 2.0 is going to be the McAlbert's undoing. If the Commonwealth had dropped the charges after trial 1, or had the jury found Karen not guilty, then all of this would have faded into the background for them. I tend to agree with you. Kyle said, I meant the arraignment testimony by Lally. Celiac sprue is the most common cause for MS or Crohn's. Thank you for clarifying. All right, my friends, let's go over the dates. The new dates for everything that we heard about today. She said that she's going to decide by Monday whether or not there's going to be a Daubert-Lanigan hearing on Richard Green. I do not think there's a legal basis for one. Nothing would surprise me at this point in this case or in this courtroom. By Wednesday next week, February 5th, the prosecution must turn over all evidence to the defense. Be prepared to discuss it next Friday, the 7th. The 6th and 7th are dates that were held for potential hearings, so they are still held for next week. The defense has been ordered to file their motion to dismiss by February 11th. By February 14th, Valentine's Day, the Commonwealth must respond to that motion to dismiss. They are going to make a motion to dismiss for extraordinary governmental misconduct. February 21st is the drop dead date for the filing of all evidentiary motions. February 18th, there will be a hearing on the motion to dismiss. Something about March 4th and 5th, evidentiary hearings. I'm not sure if those are the motions in lemonade as we call them. March 8th, there's another in-court date, something on March 18th, something on March 7th. I'm going to have to go back and watch. But there are 2 new motions just dropped less than an hour ago. Well, I don't know. Those might be the ones that we just went over. Are those the ones that we just went over? 465, 466, 467. Let me check the docket. Let me check the docket. Thank you, Karen, for buying me 3 matcha lattes, who says I'm the best YouTube channel covering this case. Informative, funny, and just a pleasure. Thank you. Snark is welcome. And then another one, an anonymous matcha latte. I appreciate all you do to keep us informed on the various cases. Thank you. Carolyn, thank you. Melanie, I would like to participate in this. However, I don't want to go to Massachusetts. Could we make a donation screenshot it, and do a raffle to have a lunch with you? Oh, Carol wants to have a lunch with me. I don't know how that would be received. I would happily donate the money to the Karen Reed Defense Fund. If there are people who are local to New York that want to have lunch with me, I don't know. I don't know if anybody would want to have lunch with me, Carolyn, but thank you for flattering me by even thinking that people might want to have lunch with me. And that's a very, very, very sweet thing. Thank you so very much. Let me just check the docket real quick. Wow. Wow, the Twitter trolls found what appears to be a mugshot of Richard Green that they are now posting on the cesspool of Twitter. But it says that he's 6'7" and 307 pounds. This is from 2016. They will stop at nothing, you guys. They will stop at nothing. Oh, people would travel to have lunch with me. That's so sweet. We could even do a Zoom lunch. Yeah, Zoom is an option. We could do that. Oh, you would have a meal of food with me. Hashtag Hank. That is very sweet. Somebody says it's not him, but because of the eye color. But look, they're posting a I mean, the mugshot does look like him. But I'm telling you, this is what they will stop at nothing. Yeah, I'm thinking it meant 5'7", but it's wrong. And those charges may have been dismissed. So it is not, yeah. Clamasu says they need to be very, very careful as the doxing laws of Florida are very strict. Thank you, Clamasu, for pointing that out. I'm not even going to publish it. I'm going to tell you that it's out there if you want to go find it yourself, but they will stop at nothing. It doesn't make him less qualified. Oh, Jazia, thank you. $75 to 75K and lattes. You're the greatest. You guys are awesome. So awesome. Yeah, they better watch out. I mean, some of those people already have like potential pending charges against them. So I don't know. I'm not here to give legal advice to anybody, but you know, didn't Mark Bettero request Morrissey's phone? Yes. And that is still in the process of being, I believe, turned over in Aidan Carney's case. I mean, wow. Wow. All right, I'm still here. So if you have any final thoughts, questions, concerns, get them in. Get them in there. Before we go. And in case I neglected to, I think I got this. Kelly, Amanda, Kelly, Sharon, Stephanie on Venmo. Sally, thank you so very much. Heather, got everybody. Lisa, pretty sure I got everybody. That's one way of putting it, Susie Q. God, they are gross. Witness harassment. Oh, witness harassment. You know, the witness harassment statute in Massachusetts is very, very broad. I mean, it even extends to rubber duckies. Yes, Charlie Lynn. Yes, thank you. Witness intimidation, could it be? Those trolls have so much time on their hands. Surely they could put it to better use. I don't know. Wouldn't it be amazing if they could channel all of that energy into good? Into good? Thank you, Bill. Thanks, Bill, for saying I have great commentary. I love it. I think it's a typo, and I think they probably meant 5'7", Zoe. But yeah, remember Richard Tellis in Nevada claiming he was 6'5" and 5'6" with lifts in his shoes. Oh my gosh, I miss that. I miss the oddity of the Robert Tellis trial. Boss baby. New motions 469 and 469. 469 and 469. Oh, sorry. Sorry, I forgot. I got so easily distracted. Mass courts. Hold on. I don't know if my amazing paralegal is in the chat or if anybody has them and they want to email them to me. Fanbase@mlittleLaw.com. Because I think the last one that I have here is what number did we say? We were up to 466, I think. Yeah, the rims in Robert Tellis's SUV. The rims. Oh my God, that was crazy. Cheryl, I'm not telling my birthday. I'm not telling my birthday. You kidding me? But I am an Aquarius. I'll tell you that. Maybe my birthday already happened. Maybe it didn't. Hang on. I mean, it's like, you know, that you're living in like a scary world. When I started this YouTube channel, I had no idea that such hateful, nasty, mean, vitriolic people existed in the world. I guess I was a little bit naive about it. Maybe if I were to do this again, maybe I wouldn't have used my real name, but I never thought it would be a problem. I'm an attorney and people know who I am. And I've handled, you know, cases like the Catholic Church cases that were widely publicized and, you know, written about. And thank you, Mama She. Oh my gosh, for another 25. You're the greatest. I didn't know that they were going to come for me and my kids and my family and try and put my address on Twitter and take things off my kids' Instagram and dox their locations. Like, it's vile what's happened to me. It's vile. So I unfortunately, although I'd love to share more of my life with you guys, it's something that I just can't do. All right, let's see. We have there's a 469 motion, Commonwealth and defendants joint motion for reconstruction and certification of the record. I think that might have to do, if it's a joint motion, may have to do with the sidebar conferences. I'm not sure. The Commonwealth's motion for protective order regarding communications produced in the Commonwealth's Notice of Discovery 57 has been so ordered. So that means that there's a protective order on Commonwealth's Notice of Discovery 57, which we haven't seen yet, and I guess we won't because it's impounded. 56 we saw and went over yesterday. So I'm not sure. My amazing paralegal says 468 and 469 are not, they haven't been filed yet, but that's okay because I don't think it's anything earth-shattering right now. Okay, so I think we've covered just about everything that we can cover for now. Thank you so very much. Thank you. It is going to be my 29th birthday again. I'm 29 again. Isn't that awesome? Let's and the Karen Reed Defense Fund is up to $624,863, but understand that most of that money has already been spent. It's already been spent. So there is that. Oh, Charlie Lynn, thanks for the 20. The haters love to say Yannetti admitted she was guilty because he said there's no criminal intent, where he was clearly asserting that the Commonwealth had not met the threshold for her charges. Thank you, Charlie Lynn, for pointing that out. Thank you. Although he did say something on the courthouse steps, and I don't have that video pulled up right now, that may have leaned a little bit towards something that we did not see during the hearing that we just watched, and I can't remember, so I don't want to misstate. Charlie says witness intimidation. Thank you, Charlie, for another 2. X is from GRX, which is he or she, so it could be kid or I don't. Okay. Okay, thank you, Kyle. Thanks for another 5. Yes, they're posted, but they're not up yet. Thank you, Bill, for thanking me for what I do. Thank you, everyone, for hanging out with me for a very long day that it has been here. Not that long, because we do have much longer days on occasions. So It's been 5 hours and 8 minutes, and I loved every minute of it because you guys are ducking amazing. Thank you to the moderators for keeping it classy today. Thank you to all of you who were with me for the 75,000 milestone today. See what we're up to now. 75,075. So thank you, 75075. I'm going to go look up my angel numbers about what 75 stands for because here it is. I'm just going to preserve this for posterity. Thank you for sharing this moment with me. It is a very, very special moment and coming full circle from where I started on this channel. The first videos I ever posted were about Kevin Costner's divorce. Do you remember? Who's been here since Kevin Costner's divorce? Guess what happened yesterday? Christine Baumgarten, the now divorced wife of Kevin Costner, got engaged to Kevin Costner's bestie, Josh Connor. Oh, yes. Oh, yes. Oh, yes. We like things to come full circle. And what a biatch. Remember, she was looking for something like $250,000 a month in child support. And now it may turn out, yep, I'm going to pull it up for you because I know you guys like receipts. It may have been that yes, oh, yes, oh, yes, she indeed might have been having a relationship with this guy just as Kevin Costner suspected. What the hell's her name? Christine Baumgartner? Oh, Baumgartner. Yep, here it is. We have come full circle. Kevin Costner's ex-wife, Christine Baumgartner, flashes engagement ring after moving on with his ex-pal, bestie, Josh Connor. Remember, there were some pictures of her during the pendency of when they were fighting out the divorce, and he was trying to get her evicted from his house because that's what the prenup said. Josh Connor. There she is. Flashing her ring. No shame. Zero shame. Leaving the Honor Bar in Montecito, California with her husband-to-be, 49-year-old Josh Connor, on Thursday, January 30th. Wow, just wow. And that wasn't even the first article. The first article was yesterday, and I bookmarked it because I wanted to share it with you. Here it is. Kevin Costner's ex-wife, Christine Baumgartner, engaged to his former friend after bitter divorce. She says they've only been dating for a year. Well, that's so funny because that's how long my channel's been around, a little over a year. And he did a beachside proposal in Santa Barbara on January 26th. Less than 1 year after finalizing her divorce with Costner. Well, she had to get her judgment. She had to get her money in there and her child support and all that other good stuff. So that's it. Thank you so much for hanging out with me today for all this time. Thank you to the moderators for keeping it classy. Thank you, Charles, for your last minute super chat from South Africa. Canton has a VR virtual reality camera system. They can also change an LHD car to an RHD car. I don't know what that means, but maybe somebody does. Thank you so very much. Stay cool, stay kind, stay classy. Don't let the haters get you down, my friends. I'll see you real soon. Make sure you have your notifications set and you smash that like button and the subscribe button because it's free. Stay cool, stay kind, stay classy. Peace out. I'll see you again real soon. Have a great rest of your day.